If everyone could take their seats, please, we'll get started here in just a minute. The committee will come to order. Committee will come to order, and the chair will recognize himself for a few opening remarks. First of all, in a sort of administrative nature, as members know, we have two scheduled votes on the House floor later today. The first, roughly 1:30 p.m., the second, roughly 5 p.m. So between House votes and committee, buckle in for a long day. I have in front of me already a list of 41 amendments, and we are told that we should anticipate more, although we've not seen them. I mentioned this to our members earlier this morning, but I want to reiterate to both sides here now that just because the House adjourns tonight and the Republican retreat is tomorrow morning, we will continue the organizational meeting following the dinner hour. That will be roughly 8:30 to 9 o'clock, and then we will go until we conclude. So we will try to take up every amendment, and we will go until we finish our work. I want to warmly welcome my fellow members of the Committee on Energy and Commerce to our organizational meeting for the 115th Congress. I'm humbled and honored to serve as your chairman in this Congress. As your chairman, I'd like to start this hearing by paying tribute to the last person who had the gavel, and that is my friend from Michigan, our friend, Fred Upton. Fred had an exemplary record of bipartisan success as chairman. Just in the last Congress, this committee held 185 hearings, 175 Energy and Commerce Committee bills passed the House, 111 were signed into law. He also led the efforts to pass major legislative initiatives, such as the enactment of 21st century cures, the repeal of the SGR, opioid legislation, and pipeline safety legislation. The passage of mental health legislation led by Tim Murphy and TSCA led by John Shimkus also happened on Fred's watch. Last but not least, Fred is my good friend, and I'm grateful that he is continuing to serve on this committee as our chairman of the Subcommittee on Energy. Fred, we thank you, we salute you, and we have something for you. If you want to stand up right here, Bloomquist is... Now, this is a photo of the signing of cures, which you don't get to, go ahead. Now, you actually don't get to take that home because we're going to hang it in the committee. Yeah, no, not right there, but we're in the Transportation Committee room anyway. But and please feel free when you leave to take jurisdiction with you back to Energy and Commerce. We're going to hang that, though, in at least the Republican side, as a reminder to all of us what can be accomplished by this great committee under the leadership of Fred Upton as an inspiration for all of us. Fred, thank you for your service. Fred's work was remarkable, but it also continued a strong committee tradition of producing legislative solutions to the problems that American families face. We say it so often that we risk wearing out the phrase, but this is the best committee in the House, and we have the best members on both sides of the aisle. We are the workhorses, and we know how to get things done. The message of the last election that we all heard loud and clear is that the American people expect us to act to solve problems. I think we have a great opportunity before us to continue this committee's record of success and accomplishment, and I look forward to working with all of you to get our priorities enacted into law. Finally, I'd like to salute my ranking member, Frank Pallone. We've already sat down and talked about the ways we can work together. And I know Frank shares my commitment to this committee's work, and the achievements of the last Congress would not have happened without his support. Again, welcome back. I yield to the ranking member, Mr. Pallone, for his opening statement.
Well, first of all, thank you, Mr. Chairman, for what you said about me and also about the bipartisanship in this committee, which I certainly share, and I know all our Democratic members share. And I do want to thank Fred Upton. I think that the record of achievement, again, bipartisan achievement under Fred was just amazing. And that, you know, I have to say it was interesting, Fred, to see you on the floor. I guess it was yesterday. So even though you're no longer the chairman, you're still out there working hard every day, including yesterday when we had a number of bills that were on the suspension list. And also continuing the work of Joe Barton, too, because Joe, like Fred, has always been very bipartisan. So I look forward to working with our Republican colleagues this Congress. We both hold a great respect for this committee and know the importance of its work, and I believe the same holds true for all of our colleagues, each of whom have chosen and been assigned to serve as members of this committee. Our committee is celebrating its 222nd year in existence, and I know we're all looking forward to getting to work to build a stronger economy, create more good-paying jobs, and protect consumers. I'll have more to say later, but I would now yield back. Thank you, Mr. Chairman. Did I get that wrong, 222?
No, I think that's exactly right. I was just going to point out that one of our incredible staff members is celebrating his 22nd year working for the committee, Alan Slobodin, right over there. Today marks 22 years, and he does a great job on our oversight and investigations work. With that now, I'd like to take a moment to introduce the new Republican members of the committee, and then I know Mr. Pallone will introduce the new Democrat members. First up, Tim Walberg of the 7th District of Michigan. This committee has had the good fortune of getting the best the Michigan delegation has to offer, and we're happy to welcome Tim Walberg to Energy and Commerce. He is a pastor. He served in both Michigan and Indiana. He served for 16 years in the Michigan legislature before coming to Congress. Tim previously served on the Oversight and Government Reform Committee, continues to serve on the Education and Workforce Committee. He's married to Sue and the father of 3 children, 7 grandchildren, and 1 great-grandchild, Harley. Oh, no, wait a minute. Harley Davidson's not the great-grandchild. That's what you ride. Welcome, Mr. Walberg. Mimi Walters of the 45th District of California, a refreshing sight, with all due respect to my Democratic colleagues, a Californian on this side of the aisle. Before politics, Mimi worked as a stockbroker in California, but she also had a job that perhaps best prepared her for her current job. She worked at Fantasyland at Disneyland. Later, Mimi got her start in politics in 1996 at the local level, serving as a councilwoman and mayor of Laguna Niguel before moving on to the state legislature. She's in her 2nd term in the Congress, previously served on the House Judiciary and Transportation and Infrastructure Committees. She is married to David and a mother of 4. Mimi, we're happy to have you on the Energy and Commerce Committee. Mimi Walters. We have Ryan Costello of the 6th District of Pennsylvania. With the addition of Mr. Costello of Pennsylvania, we now have 3 Pennsylvanians on the Energy and Commerce Committee. Like Mimi, Mr. Costello has deep experience at the local level, serving on his county board as supervisor and then as chairman of that board, and also as the recorder of deeds. Only good deeds. He was first elected to Congress just 2 years ago and served during the 114th Congress on the Veterans Affairs Committee and the Transportation and Infrastructure Committee. A few fun facts about Mr. Costello. He can dunk a basketball. So get ready if you get on a basketball court with him. He is married to Christine and the father of Ryan Jr. Welcome, Ryan Costello. And our final new member on the committee is Buddy Carter of the 1st District of Georgia. He is from Pooler, Georgia, and served his hometown on the Planning and Zoning Commissions and as mayor from 1996 through 2004. Buddy then moved on to the Georgia legislature in 2005, was elected to Congress in 2014. He's the only pharmacist in the Congress, and we expect that experience to be very useful on the Health Subcommittee, of which he's a member. Buddy's married to Amy, and they have 3 sons and 3 grandchildren. Welcome to the Energy and Commerce Committee, Mr. Carter. And now I recognize Mr. Pallone to introduce our new Democratic members of the Energy and Commerce Committee.
Thank you, Mr. Chairman. I'm especially pleased that we're welcoming 3 new Democrats to the committee. First is Raul Ruiz, who represents California's 36th Congressional District, is a proud son of farm workers growing up in Coachella. Raul has been a trailblazer in his community, achieving his lifelong dream of becoming a physician. As the only Democratic physician on the committee, Raul brings an important voice to the table. I look forward to Raul contributing his expertise in health care on this committee, as well as his work on the environment. Raul? Okay. Next is Scott Peters, who's an environmental leader who represents the 52nd Congressional District, which includes northern San Diego and a lot of the coast just north of San Diego. He worked at the EPA as an economist during the last years of the Carter administration and has expertise on Superfund as well as a number of other environmental policies. So we look forward to having that expertise on the committee. Scott? And last but certainly not least is Debbie Dingell from the 12th Congressional District of Michigan. Debbie's vast experience at building coalitions to promote auto and manufacturing jobs is going to be essential as we work to build a stronger economy. As the founder and past chair of the National Women's Health Resource Center, Debbie understands the importance of access to health care. Congratulations to Debbie as well.
Welcome, Debbie.
So again, I yield back, Mr. Chairman.
Thank you, Mr. Pallone, and welcome to all our members returning to the committee and our new members joining us. All right, we're now going to begin the business meeting with the resolution to adopt the committee rules for this Congress. The chair has a resolution at the desk and asks the clerk to report.
A resolution offered by Mr. Walden.
Without objection, the resolution will be considered as read, and the chair will recognize himself for 5 minutes. Before I do that, I think we're going to do the colloquies, correct? All right, I'll recognize myself, and Mr. Pallone and I have a couple of colloquies that we had discussed, and so with that, I would now recognize the gentleman from New Jersey, Mr. Pallone.
I have two, Mr. Chairman, one on scheduling and one on letters of exchange. You want to do the scheduling one first?
I think that's fine. Let me figure out which one. Scheduling, right here, we're good. Yep.
Okay. This relates to the matter of whether full committee and subcommittee chairmen will refrain in this Congress from scheduling committee matter markups on days and at times that conflict with important Democratic caucus and leadership functions. Last Congress, the majority would occasionally schedule opening statements for markups on the evenings before the day on which the markup was noticed, and at times, the majority would also notice midweek hearings and markups on days and at times that conflicted with regularly scheduled Democratic morning caucus and whip meetings. And as a result of these scheduling actions, some members in the minority, including full and subcommittee ranking members, would have to choose between events scheduled at competing times, both being equally important. And although I and my staff often brought this problem to the attention of our past chairman and senior committee staff, it was never completely resolved. So this is one matter, Mr. Chairman, with all due respect, that requires, I think, urgent attention, as it does impact a number of really good and hardworking members. And it's a problem that I think we should be able to find a solution for. I yield to the chairman.
I thank the gentleman. I agree with the ranking member. This is an important issue and important to members to be able to attend these caucus meetings, and I know no one on either side of the aisle ever misses their caucus meetings. I acknowledge there have been some unintended conflicts with these meetings on a few occasions. On a few of those, the hearings were planned or noticed prior to the announcement of the caucus meeting. As I mentioned when we met privately, we have a lot of work to do, but we will work to our best ability to minimize the conflicts where we can, especially respecting the caucus meetings of both parties.
So, Mr. Chairman, I think, again, I just think that this is important in terms of making sure that all members be heard, because obviously the committee and what we do is very important. So if we do as you said, I think it allows for more full and broader participation by our members across all committee hearings and markups. And so I thank the gentleman.
Thank the gentleman, and I appreciate your concerns, and you have my assurance we'll work closely with you and your staff, and I appreciate your raising it today.
And the second one I have is with regard to exchange of letters and relates to the committee's jurisdiction. Based on listings of enacted House bills, bills being reported out of various committees in the 114th Congress, and by consulting publicly disclosed letters of exchange found in the congressional record, we believe that the majority has sometimes not provided the minority with regular notification of its decisions to waive committee jurisdiction over legislative matters. So I'm bringing this to your attention, Mr. Chairman, with the hope that these decisions are communicated in a more comprehensive and timely manner to me and my colleagues in the minority, as well as our staff.
Will the ranking member yield?
Yes.
Thank you for bringing this important matter to my attention as well. I've also been advised of this matter as well as by our staff, rising out of discussions they've had around today's organizational meeting with your staff.
And I want to thank our staffs after with consulting with us to meet further to find an acceptable way to resolve this problem, Mr. Chairman.
And when we met just a few weeks ago, we also discussed this matter. I know of the importance of it. I committed to you then that we will promptly share any exchange of letters we execute with other committees. We already did this yesterday when we executed an exchange of letters with committees who received additional referrals on the suspension bills that were on the floor yesterday. We sent those letter exchanges to your office immediately so you had a copy. I know you share my interest in protecting, defending, and perhaps expanding our jurisdiction, so we pledge to continue working with you to do so.
Oh, I like that idea of expanding our jurisdiction. That sounds even better. So I want to thank the chairman for your assistance in this matter. And anything we can do to ensure that this system captures all exchange letters would be most desirable, Mr. Chairman.
Yes, that will be our objective.
All right, thank you again.
Okay, I now recognize myself to discuss the Energy and Commerce rules for the 115th Congress. Today's rules package contains just two changes from the last rules. The first is an administrative update to Rule 7A of the committee rules. In the preceding Congresses, the committee was required to maintain a journal. The journal compiled the following pieces of information into one document: attendance records for each committee meeting, records of recorded votes, a description of each recorded vote. Now, this document was not posted publicly, but the committee rules require the committee to make this available to the minority at their request. The journal in many ways is frankly a relic of the past and how the committee used to maintain records and make them available. We used to keep everything on paper in our offices. Now we post committee records electronically on our website. The House and the committee's use of the public document repository and the committee website to make markup records available to the public, and the House's requirement in Rule 11 to make markup records available in electronic form within 48 hours of the markup, frankly, has overtaken the need to have a written journal. Already, our committee rules require that we publicly post the recorded votes that are compiled in the journal to the House repository and the committee website immediately following all committee markups. So those are already posted electronically. Our proposed change in this rules package will also memorialize current committee practice by requiring us to publicly post attendance records from markups, which is one piece of the journal. Bottom line is that all the information in the journal will continue to be available to all members and the public. We're simply eliminating the duplicative requirement of keeping a separate paper document with this information and making conforming changes to Rule 7. So that's the first change in the rules. We're going to modernize the committee's record keeping and dispense with a printed document that I'm not sure anybody accessed. It's all online. The second change to committee rules is also to Rule 7 and relates to the chair's authority to postpone recorded votes. Previously, the chair needed to obtain the ranking member's concurrence to postpone votes. The change we're proposing is to give the chair the authority to postpone votes after consulting with the ranking member. I've talked with the ranking member about this change, and our staffs have also discussed this extensively. While it is a change from past committee practice, this authority is commonly granted to House committees. In fact, every other committee in the House, every other committee but E&C and Armed Services provides the chair with authority to postpone votes. It gives added flexibility to the chair to manage the markups efficiently and to be accommodating of member scheduling needs on both sides of the aisle, especially in those cases where our committee markups conflict with floor votes or committee bills on the floor. I did hear Ranking Member Pallone's concerns about this proposed rules. To address the concern, this rule requires that I consult with him, which I'm happy to do, before postponing any recorded vote. It also requires that I provide reasonable notice to all members of when the postponed vote will take place. I pledge that I'll work closely with you on determining a time to resume proceedings on a postponed matter, and I will use this authority judiciously and fairly. I now recognize Mr. Pallone for a 5-minute statement.
Thank you, Mr. Chairman. Each of our committee's 24 Democrats value this opportunity to discuss and debate the committee rules we will be voting on later today. Mr. Chairman, the Republican rules package, which Chairman Walden just called up from the desk, in my opinion, does not maintain sufficient transparency or encourage enough trust and consensus building between committee Republicans and Democrats. The package also does little on the whole to inject more transparency into areas where past experience shows us that more real transparency and openness are needed. To that extent, we will be raising some questions as well as offering amendments regarding publicly posting subpoenas, exchange of letters pertaining to committee jurisdiction, although we did that already, how staff conducts transcribed interviews and witness hearing disclosures. Two of the proposed rules are especially problematic from the standpoint of minority inclusion and committee transparency, and I'm referencing now Rules 7A and 7B relating to record votes and Rule 16 related to subpoena power. With regard to the subpoena power, we're fundamentally opposed to unilaterally delegating subpoena authority to the committee chair. Chairman Walden has agreed to give me 72 hours notice any time a subpoena is being noticed, but I strongly believe that we should return to our previous rules from the 113th Congress and before, where this was not done unilaterally. You'll remember that before we moved to any subpoenas, the ranking member would have to agree, and if he didn't, we would then have a business meeting to actually discuss the matter and take a vote. This created more accountability for actually issuing a subpoena, and then it created, I think, more transparency. Now, committee Democrats also oppose the proposed changes that are being made to Rule 7. This is actually a change from the previous Congress. In the 114th Congress, the chairman of this committee was authorized from time to time, which means not regularly or routinely, and upon concurrence with the ranking member to postpone votes. The rule had been radically reworked in the resolution that is currently before us, now appearing as Rule 7B. And what the Republicans are now proposing is to adopt a rule that merely requires consultation with the ranking member and strikes the from time to time language. And this authority would extend not only to the full committee chair, but also to the subcommittee chairs. The reason this is concerning me, Mr. Chairman, is based on my experience. I used to be a member for many years of the Resources Committee, and I saw firsthand how constantly rolling votes led to less interaction between the parties during a markup. And less interaction leads to less bipartisanship and reduces the possibility for compromise. And compromise simply isn't possible, in my opinion, if we're not all here actually marking up legislation and listening to each other. Over time, I saw the Resources Committee become more partisan and divisive, and I think a lot of that had to do with rolling votes. And so this is troubling, as we know for a fact that our committee's bipartisan success and achievements are directly linked to intra-committee transparency and inclusion of the minority. So taken as a whole, the Republican rules package lessens the importance of the ranking member and minority concurrence and consultation, and we'll get to more of an explanation to this as we call up the amendments. At this point, I yield back the balance of my time.
Gentleman yields back the balance of his time. Is there further discussion on the resolution? There's no further discussion. The vote occurs on the resolution. All in favor say aye.
Wait a minute, excuse me, Mr. Chairman. We're voting on the rules package now?
Well, I ask, is there any
no,
further discussion on the resolution?
We have several amendments.
Well, I figured somebody might.
I thought you were going to the rankers now. You want to do that next?
Well, I think we're doing the rules then.
Do you want to stay on the rules package?
I think we're on the rules package.
All right. Well, then we're going to have to vote.
Yeah.
You'll have to withdraw the request for a vote.
We have some amendments if you want to deal with the rules
All right.
package now. If you want to, we could do the appointment of the subcommittee rankers and members, though.
Without objection, I withdraw. We can open up to amendment, if that would be good.
Okay.
So we will do that. So does anyone seek recognition? Gentlelady from Illinois.
Well, thank you, Mr. Chairman. My amendment deals with
Matt, if you could hold, can you reference?
Oh, I'm sorry, I have an
the
amendment at the desk.
And then they will read it.
We have no amendments on the rules package.
We have no amendments on the rules package?
No.
Do you have your amendment?
I'm,
The amendment should be at the desk, Mr. Chairman.
I think we were just handed them.
Parliamentary inquiry, Mr. Chairman.
Gentleman's recognized.
Since we haven't adopted the rules package for this Congress yet, what rules are we operating under right now?
Rules of the House, I would assume, is what we're operating under as we organize.
Is it the rules of the House or the rules of the last committee?
I would defer to the council. You can just stand by on that for a second.
Okay. Well, I have another question once that was answered.
I'm sorry, I didn't hear the question, Mr. Barton.
I asked what rules we're operating under right now since we haven't adopted the proposed rules package for the committee for this Congress,
We're operating under the rules of the House.
the rules of the House. Second, what do the rules of the House say about having amendments at the desk in order to be considered?
I don't believe they specifically addressed that question.
Okay. Well, parliamentary inquiry, if the minority did not have the rules, their rules amendments, the amendments to the rules of the committee at the desk, are they in order to be considered?
I think in the spirit of comedy, yes.
In the spirit of comedy, okay. If we're going to be commodious, if that's the right term, then I'm okay with that. I yield back.
Yeah, thank you. Did we find Ms. Schakowsky's amendment?
We just got the copy, and this is to Rule 16, correct? I'm just making
Ms.
sure. that's the
Schakowsky,
right
can you
version.
tell us can you reference the rule, the amendment you're asking to be considered?
my amendment to Rule 16. You have it.
Okay, we now have that. The clerk shall report the amendment.
Amendment to the committee rules offered by Ms. Schakowsky.
Without objection, the amendment shall be considered as read. The clerks will distribute the amendment.
Thank you, Mr. Chairman. And my understanding is that the amendments actually were all at the desk, so we're all straight now, right? You have them all? Okay. So my amendment deals with subpoena power and would ensure transparency when the committee uses subpoena power. It would require subpoenas to be posted on the committee's website within 1 day of issuance. In addition, it would provide for consultation with the ranking member on redactions necessary to protect individual privacy and security. And let me be clear, this is only one of several that deal with subpoena power, which is one of the most powerful tools of government. They compel people to turn over information, sometimes sensitive and personal information against their will, to the government. We should be transparent in our use of this power as we use it in legitimate investigations. In the last Congress, I served as ranking member of the Select Investigative Panel. I feel strongly that we need to have uniform, fair rules for subpoena power because I saw what happened when this power was abused by the Select Panel. Select Panel Chair Marsha Blackburn issued 36 subpoenas to physicians, medical researchers, small businesses, local government offices, and others. All were issued unilaterally by the chair without any effort to consult with me, the ranking member, as informing me is not the same as consulting. The Select Investigative Panel did not debate or vote on the subpoenas. The chair then refused to provide Democratic members of the panel with copies of the subpoena, telling us that we would receive our copy only after they were issued. Some of those subpoenas were ridiculously overbroad, probing into personal matters that Congress had no business examining. Many had unrealistic deadlines, and 30 of the 36 subpoenas were sent without any effort to obtain voluntary compliance first. Oftentimes, it was the very first contact these individuals had had with the panel. We need rules to ensure that our committee's investigations are fair, balanced, and fact-driven. The American people should be extremely concerned that a single member of Congress can demand information from private citizens under the threat of contempt. My Democratic colleagues and I have developed some simple proposals to ensure that we use subpoena power judiciously, and my amendment would provide greater overall transparency and accountability regarding subpoena power. It would ask for redacted copies copies of subpoenas to be online within 24 hours, ensuring a record of subpoena is easily available to members, staff, and the American people. And I would urge my colleagues, in the name of fairness, to please support this amendment. I yield back.
Would the gentlewoman yield?
I would happily yield the balance of my time. Yes.
Mr. Chairman, I think this is so important from the issue of transparency, which of course is the main focus really of why we're offering all these amendments. But I also think that the second part of this that says that the chair shall consult with the ranking minority member in advance of any redactions necessary to protect the privacy and security of individuals or entities subject to subpoena is really important, because that can be abused, and it can really have a negative impact on not only the individuals and their lives, but also their work. And we saw a lot of that with the special subcommittee, that we're concerned about the impact of these subpoenas on the activities and the work that the people that were being subpoenaed, that was taking place. So I just want to urge my colleagues to support this. It's important both from a transparency point of view and also from a privacy point of view, I think, of the people that are being subpoenaed. I yield back.
And I yield back.
Gentlelady yields back balance for time. I will speak in opposition to this. First of all, I think we need to understand this is the same language in the Energy and Commerce Committee rules that was there in the last Congress. We are talking about the operation of the full committee here. And the chairman last Congress used subpoena power a grand total of 5 times. And that is something we recognize as a very powerful tool. We fully respect its power. We also recognize that there are situations where you have whistleblowers that, if the subpoena were to go public, could cause major chilling effect on the ability of whistleblowers to come forward. We also have situations where we have friendly subpoenas, and there are certain entities and all that would not want that necessarily made public. I think this is a solution in search of a problem that has not existed on the full committee and will not exist going forward. I fully respect the power of a subpoena. We already have Rule 16 that deals with this, and so I would oppose the gentlelady's amendment.
If the gentleman would yield.
And I would yield to former Chairman Upton.
As I recall, and I'll let the council verify this, as I recall, the rule that we're doing here, or the amendment that's part of our rules and that we adopted 2 years ago, was the same language, same authority that Henry Waxman had when he chaired the Oversight Committee. Am I correct? I'm not correct. So I'll strike those words, and just say that in the last 2 years under this authority, I used it only 5 times. Yeah. And I would say I would either find my friend, the ranking member, on the floor, or use the phone. Sometimes it was used as a threat to try and get more information, but I thought that it worked fairly well, and we had what I at least thought on our side was a pretty good relationship, as I gave a heads up on those 5 occasions that I used it over the course of the 2 years.
Would the gentleman yield? So
I don't have the time. I'll yield back to the gentleman from.
I'd be happy to yield the
So
gentlelady.
here's my question. Does this rule then apply to subcommittees? What power does a subcommittee chair have then?
I will defer to the council on this. Who has authority to issue subpoenas?
On our committee rules, that authority is designated to the chair, if you read the text of Rule 16. And I can read it to you. The power to authorize and issue subpoenas is delegated to the chair of the full committee as provided for under Clause 2, M3A, of Rule 11. And if you look also at the text of Rule 11, it specifies that authorized subpoenas shall be signed by the chair of the committee or by a member designated by the committee. And so Chairman Walden, for our subpoenas to be valid when they're served, he would sign our subpoenas.
Or designate. It says or designee.
But that's not what our committee, it also talks about the rules that our committee rules then delegate that authority to him, and he would have to delegate it, which he is not.
And can I ask counsel, I'll reclaim my time, do other committees require posting of subpoenas on their websites you're aware of?
There are a variety of rules that different committees have on the authority of the chair. Some do not provide for consultation as we require in our committee rules. We require that you report the issuance to the members once we have issued a subpoena under Chairman Walden's authority. They do not require public posting, although in each instance when we issued a subpoena in the last Congress, we did 5, we did post those on our website. That's how we handle that.
Are there other safeguards in our rules regarding subpoena authority? Other notice requirements and
So
things?
72 hours in advance to the extent practicable. We consult with the ranking member, and I believe that Chairman Upton did that each time, sometimes even further in advance than 72 hours. We shall notify you of it, and then the third requirement is reporting it to the committee members,
Okay.
which
I,
all committees have.
Yield back the balance of my time. Are there other people seeking recognition? Gentlelady from California. Ms.
Thank you,
Esch,
Mr. Chairman,
recognized.
very much. I just want to make a comment on this because obviously the committee rules, the full committee rules extend to the subcommittee and how the subcommittees will operate, et cetera, et cetera. But we're talking about a select committee that was put together, I believe, by the Speaker, and that even though it operated out of Energy and Commerce, it had another whole set of rules to it. Now, I think there was, to put it minimally, a discoloration of this committee, the Energy and Commerce Committee, in terms of the rules, most especially when it came to subpoena and how subpoenas were used. Major newspapers editorialized on this across the country. So while usually rules in the committee are an internal discussion, this went viral, both in the print press and otherwise. So
Would the gentlelady?
yeah, I'd
when
be
you get
happy to yield. My point is that we have a problem because this was within the Energy and Commerce Committee, but our rules did not apply to that select committee. And while I think some of my colleagues would not believe there was abuse, I do. I think it was, no member of Congress should do that. I'd be happy to yield.
I appreciate that, and I thank the gentlelady for yielding. The Select Committee was a product of the House.
Right, that's what I
By a
said,
resolution of the House that granted certain authorities to the Select Committee, which in effect precluded, for example, the chairman of this committee from having veto power over subpoenas.
I understand
So
that.
that
but,
is
but
something that
reclaiming
was
my time, we
above our
now have
control.
seen so that if something like this comes up again before the full House, I think that
Right.
on the Republican and the Democratic
Right.
side, on a bipartisan basis, we should not only review what those subpoena powers are, but stand together and say, in the name of our committee, this shouldn't be done, and that we do that on a bipartisan basis. So I appreciate it.
Would you
Yeah.
yield one
I'd
more
be
time?
glad to.
Because I
Glad to.
believe what would happen, I share your concern, I believe what would happen.
Yeah, we have a problem.
Would be that the resolution of the House would still trump our committee rules. That's what happened here.
I understand that. I'm saying,
there's-
reclaiming my time, Mr. Chairman, that understanding that and understanding how this really went wrong, and it was under the banner of the Energy and Commerce Committee, that if and when the Speaker proposes another select committee, that we be very selective about what we accept in terms of the rules that would apply to it. And with that, I would...
Would the gentlewoman yield?
I'd be glad to.
I know we want to go to a vote on this, but I just want to say one thing. I think that when the chairman talks about the whistleblower, I think the second part of Ms. Schakowsky's amendment effectively deals with this, where she says that the chair shall consult the rank in advance of any redaction necessary to protect the privacy and security. I mean, you are anticipating those types of situations to protect the privacy. So again, I know the chairman's raising that, but I think that Ms. Schakowsky's amendment handles that situation. Did you want to? I'll yield to you. Well, I guess it's Anna's time. Anna, would you yield her? Janice a minute or whatever time?
You know, my understanding was that this was, that I don't want to relitigate the whole select panel, but that it was a subcommittee of the Energy and Commerce Committee. We had multiple times, yes, it was. And that multiple times we asked for a committee, business committee meeting to decide on rules, and that would have included rules on subpoena. I just think that this amendment now says, let's make transparency, do transparency by having 24-hour issuance of a subpoena and consulting with the ranking minority member in advance as to redactions that are necessary to protect the privacy and security of individuals or entities subject to the subpoena, which came up also in this issue of why are names being put out there and jeopardizing the privacy of individuals that were subpoenaed, not knowing, not consulting with in a meaningful way with the minority. This amendment, I think, deals with that.
So if I can just say, I know we're going to go to votes here in a minute. I would remind members we have 41 amendments, at least, pending to dispense with between now and sometime tomorrow morning. On this issue, it was not a subcommittee of this committee because, as you know, there were members not on this committee who were on that select panel. So it wasn't, the resolution treated it different. It housed it here, but it was not one of our 6 subcommittees. And the subpoena authority was not our subpoena authority on energy and commerce. It derived its power from the resolution in the House. So it was separate, even though it was housed here. I understand, I respect my colleagues' comments, but it was not actually a subcommittee. Are there other members seeking recognition? I'd yield to my friend from California.
Thank you, Mr. Chairman. Whenever the committee reconstitutes itself, I always raise this, and that is that a confirmation that we have in the full committee's rules.
Can I stop you
Yes.
for a second? I'm reminded you've already spoken. If somebody else would yield Ms.
Somebody
Eshu
else?
time, I would recognize the gentleman from Pennsylvania who yields to the gentlelady from California.
Thank you. And that is that the committee rules do indeed provide for members of subcommittees, when they are not a member of a particular subcommittee, that they can be a guest of that subcommittee and participate in it. I think it's very important. It's good. It's wonderful and important for the new members on both sides of the aisle to know. And I know I've exercised it many times over the years.
I appreciate that. Maybe we can get to that in a minute since we have
Just
this
a
pending
confirmation of it.
issue.
Sure.
Yeah, I think it's important for our members to be able to sit in on other subcommittees.
But
I
it's
think
just a
that's been
confirmation, it's in the rules. Yeah.
It's not in the rules, but it's been our practice as a committee. I don't think it's been in the rules. I'd yield, well, I'll let you two yield back and forth here.
If no one else wants time, I'll yield back.
If Mr. Green yields back his time, then I'd recognize gentleman from Pennsylvania.
I'm sorry, I thought you had yielded me the time. And
Oh,
I
I'm
yielded
sorry.
to Anna.
If I did, then
And
I
I'm
would
going to
yield.
yield it back if nobody else wants
Oh,
it.
got it.
Thank you.
Gentleman yields back the balance of his time. Are there other members seeking recognition? If not, the ranking member has asked for a recorded vote on this, so the clerk will call the roll.
Mr. Barton. Mr. Barton votes no. Mr. Upton. Mr. Upton votes no. Mr. Shimkus. Mr. Shimkus votes no. Mr. Murphy. Mr. Murphy votes no. Mr. Burgess. Mr. Burgess votes no. Ms. Blackburn. Ms. Blackburn votes no. Mr. Scalise. Mr. Scalise votes no. Mr. Latta. Mr. Latta votes no. Mrs. McMorris-Rogers. Mrs. McMorris-Rogers votes no. Mr. Harper. Mr. Harper votes no. Mr. Lance. Mr. Lance votes no. Mr. Guthrie. Mr. Guthrie votes no. Mr. Olson. Mr. Olson votes no. Mr. McKinley. Mr. McKinley votes no. Mr. Kinzinger. Mr. Kinzinger votes no. Mr. Griffith. Mr. Griffith votes no. Mr. Bilirakis. Mr. Bilirakis votes no. Mr. Johnson. No. Mr. Johnson votes no. Mr. Long.
No.
Mr. Long votes no. Mr. Bouchon. Mr. Bouchon votes no. Mr. Flores. Mr. Flores votes no. Ms. Brooks. Ms. Brooks votes no. Mr. Mullen. No. Mr. Mullen votes no. Mr. Hudson. Mr. Hudson votes no. Mr. Collins. Mr. Collins votes no. Mr. Kramer. Mr. Kramer votes no. Mr. Wahlberg. Mr. Wahlberg votes no. Ms. Waters. Ms. Walters. No. Ms. Walters votes no. Mr. Costello. No. Mr. Costello votes no. Mr. Carter.
No.
Mr. Carter votes no. Mr. Pallone.
Votes aye.
Mr. Pallone votes aye. Mr. Rush. Ms. Eshoo. Ms. Eshoo votes aye. Mr. Engel. Mr. Engel votes aye. Mr. Green. Mr. Green votes aye. Ms. DeGette. Ms. DeGette votes aye. Mr. Doyle. Mr. Doyle votes aye. Ms. Schakowsky. Ms. Schakowsky votes aye. Mr. Butterfield. Mr. Butterfield votes aye. Ms. Matsui. Ms. Matsui votes aye. Ms. Castor. Ms. Castor votes aye. Mr. Sarbanes. Mr. Sarbanes votes aye. Mr. McNerney. Mr. McNerney votes aye. Mr. Welch. Mr. Welch votes aye. Mr. Lujan. Mr. Lujan votes aye. Mr. Tonko. Mr. Tonko votes aye. Ms. Clark. Ms. Clark votes aye. Mr. Loebsack. Mr. Loebsack votes aye. Mr. Schrader. Mr. Schrader votes aye. Mr. Kennedy. Mr. Kennedy votes aye. Mr. Cardenas. Mr. Cardenas votes aye. Mr. Ruiz. Mr. Ruiz votes aye. Mr. Peters. Mr. Peters votes aye. Ms. Dingle. Ms. Dingle votes aye. Chairman Walden.
Walden votes no.
Chairman Walden votes no. Yep. Mr. Chairman, on that vote, there were 23 ayes and 31 nays.
23 ayes, 31 nays. The amendment is not adopted. The committee will stand in recess until immediately following votes on the House floor, when we will resume our markup of our committee rules. We stand in recess. If members will begin to take their seats, and our guests in the audience as well, we can close the doors. I know we have 40 amendments left to consider, so we want to get going here. I know members were over on the floor and are returning as well. So I'll call the full Energy and Commerce Committee back to order, and I'd ask members to take their seats. Are there other members who seek recognition?
Mr. Chairman,
For what purpose, gentleman from New Jersey seek recognition?
I have an amendment that...
Gentleman has an amendment at the desk. Can you describe it?
I don't know if these numbers are the same. Is this number 4? It has to do with the subpoena authority.
So it'd be
Number 4, perhaps.
maybe Pallone number 4, perhaps? We'll have our clerks find that.
They are not numbered, is it?
Okay, this is the one on committee subpoena authority that deals with the concurrence of the ranking member.
So it starts out, the chairman of the committee may, after consultation, and it goes on to say, if the ranking minority member objects, that's that one, right?
Yes.
Okay,
Okay.
it's this.
The clerk will report the amendment.
Amendment to committee rules offered by Mr. Pallone.
Where is the language on that? Is, without objection, the further reading of the amendment is suspended. The gentleman's recognized to debate his amendment.
Thank you, Mr. Chairman. I'd like to offer an amendment to require the chair to secure the concurrence of the ranking member prior to the issuance of a committee subpoena. This is what I talked about before when we were discussing the rules. Under my amendment, if the ranking member objects to the proposed subpoena, the matter is referred to the committee for a vote. This has been the longstanding precedent and practice in our committee until the last Congress. In the last Congress, this committee changed the rule by giving the chair the power to unilaterally issue subpoenas without minority concurrence and without a vote of the committee. I spoke in opposition to this rule change then, and I continue to oppose it today. This rules change eliminates an important minority right by requiring zero input from the minority before a subpoena is issued. And I think this is contrary to the bipartisan tradition of this committee, and I frankly think continued use of this authority for partisan purposes could undermine our ability to work together on the important issues of the day. But eliminating the requirement of the ranking member's concurrence is about more than minority rights. It's about procedural fairness and transparency. The subpoena power is a serious power, and wielding it responsibly is a serious obligation. It's not only the power to compel testimony and documents, it represents the power to tarnish the reputation of individual Americans and to bring down entire companies. To vest this power in one person, I just think is a bad idea. Without procedural protections, there's a huge potential for abuse. Chairman Walden, I acknowledge that your predecessor, Representative Upton, used this power judiciously and recognized the gravity and the seriousness of exercising the subpoena power, and I take you at your word when you say that you will as well. But we in the minority, as well as individuals who are targets of the committee's subpoenas, should not have to rely on the goodwill and discretion of just one individual. There should be procedural protections in place to ensure that this power is not abused. We have certainly seen instances where the power was abused to the detriment of the institution of Congress and to the detriment of many individual Americans. Concurrence of the ranking member and a committee vote ensures a fairer and more transparent process. In the event of a committee business meeting to authorize a subpoena, we can have a transparent debate about whether the subpoena is necessary, what's the appropriate scope, and whether or not efforts to obtain voluntary compliance have truly been exhausted. Additionally, I can't see how scheduling a business meeting to debate and vote on a subpoena is so burdensome that we should do away with this protection. If a subpoena is truly a last resort to obtain compliance with the committee's inquiry, adopted after months of attempts to obtain voluntary compliance, then the additional step of voting on the appropriateness of the subpoena should not be problematic. And lastly, to those of my colleagues who will argue that unilateral subpoena power is essential to our ability to conduct congressional oversight, I strongly disagree. As far as I can tell, in this committee's history, we have never thought it was necessary or advisable to adopt a rule to give the chairman unilateral subpoena authority until the last 114th Congress. It's unclear to me why such a significant break with precedent is now necessary, and I hear no compelling argument why such power was necessary when we debated this rule change in the last Congress. And so I yield. And so again, I would offer this amendment to correct what I think is a serious problem, and I yield back.
Gentleman yields back. I would seek recognition to strike the last word. Our committee actually goes beyond a number of the other committees in protecting minority rights in this area. We do provide at least 72-hour consultation with the minority. We notify the minority prior to issuance, and we report the issuance of the subpoena to all the members of the committee no later than 1 week after its issuance. All the subpoenas Chairman Upton issued were posted to the committee's website. So I respect the concerns that my friend from New Jersey has raised, but I think there are adequate protections in the existing rules. We are not changing the existing rules from the way this committee operated in the last 2 years. And I would see if the former chairman would like to speak on this matter at some point, but I would rise in opposition to this proposed change. I think it's worked well the last 2 years. It is very similar to what most other committees operate on, with the exception that we actually go farther in minority protection, minority rights protection, and consultation. I recognize the gentleman from Michigan.
The gentleman will yield. I just want to say I used it sparingly. We used it to prod folks to come with a threat, but I would note that there were a couple of times when I was talking to the ranking member to give him notice, and it literally was a day or two maybe before we would have like the August break, some approved recess period, and we wanted to use the time in a responsible fashion during the break so we could conduct interviews, and there was, with only 2 rooms available, in essence, our main committee room and the subcommittee room up on 2322. We didn't, there are other hearings that are scheduled with 6 subcommittees. It would have been impossible, perhaps, on some of those occasions to do a 3-day notice, to get people there, to be, what's going to, let's face it, be pretty much a party line vote along
on the
that way.
subpoenas, yeah.
So I think that the rule that is proposed here is appropriate, and knowing you like I do, I know that you'll use it sparingly as well,
Absolutely.
as neither one of us are lawyers.
There you go. And with that, I yield back the balance of my time and ask my colleagues to oppose the rule. I'd recognize Mr. Butterfield.
Thank you, Mr. Chairman.
5 minutes.
Mr. Chairman, as you certainly know, and most of my colleagues know, I spent 15 long years as a trial judge in my state of North Carolina. And let me tell you, it is unheard of for a single person to issue a unilateral subpoena to compel a United States citizen to testify and to produce documents and to do other things. That's an awesome power. And for this committee to authorize the chair to have that power, I think goes to an extreme. And so I want to go on record supporting Mr. Pallone and what he said and what my other colleagues have said as well. Let me ask the question, is there any recourse if a citizen is served with a subpoena from this committee? Is there any recourse whatsoever to resist or to defend against the subpoena?
I would yield to the counsel since I'm not a member of the bar.
Yes.
I don't believe your mic is, there you go.
My apologies. They can work with committee counsels, but it does compel production. It requires.
The answer is no. When the chairman issues a subpoena, unless the chairman changes his mind, the subpoena is enforced.
I can speak to what's typically happened. We have issued those documents, and we've worked with their lawyers to secure compliance. And that's been our custom on this committee, to issue them and go back and
But
forth.
custom aside, in theory, a citizen has an absolute obligation to comply with the subpoena.
Just as they do when a prosecutor issues a subpoena.
And there's no right to appeal to a higher authority. Like when I was a judge, if a district attorney or a probation officer or a lawyer wanted to issue a subpoena, the defendant or the citizen, the target of the subpoena, could come to the court and ask to quash the subpoena because it was burdensome. But none of that exists here in this committee. And I want to go on record asking my colleagues to think twice about this before we give that type of power to the chair. Thank you, Mr. Chairman. I yield back.
Gentleman yields back. The other member seeking recognition. Gentleman from Texas, Mr. Barton, the vice chair of the full committee.
Well, I wasn't going to comment, but since Mr. Butterfield gave his comments, I just want to educate members of the committee, or perhaps just new on the committee. a subpoena is a request for information, and it's being requested on behalf of the American people. You know, this committee represents the American people in all the areas of jurisdiction that the committee has. Energy and commerce subpoenas are issued to gather information. I don't know that we've ever issued a subpoena for a criminal purpose. I don't think so. It's possible, but, and I've been on the committee 30 years.
Would the gentleman yield?
Sure.
Would you acknowledge that there is potentially an opportunity to abuse that authority?
Well,
in theory, the possibility of abuse exists.
again, reclaiming my time, I've served under John Dingell, Henry Waxman, Tom Bliley, Billy Tozan, myself, Fred Upton, and now Greg Walden. None of the former chairmen ever abused the authority of the subpoena, and we had it at one time where you had to go and get a vote. You know, I've served when the subpoenas, if there was a disagreement, you had to get a vote of the committee to issue the subpoena, and I've also served where it was up to the discretion of the chairman in consultation or in conjunction with the ranking member. We issue probably fewer subpoenas than any other major committee, and again, every subpoena that I can recollect was simply to gather information either at the full committee level or in some cases at the Oversight and Investigation Subcommittee level for hearings that were public hearings. And we had a lot of people kick back on wanting to comply, but because of the commitment of the staffs on both sides of the aisle, I'm not aware that we've ever had a non-compliance problem, that they've always, well, except with the Obama administration, who had to be brought to the table kicking and screaming. So I understand the sensitivity on the minority side to the subpoena issue, but at least as it's been handled in the last 30 years, it's, in my opinion, been handled appropriately.
Gentleman yields back. Are there other members seeking recognition? Gentleman from Texas, Mr. Green.
Mr. Chairman, I'll be brief, but our camaraderie in our committee traditionally is working together, and I've been on it since '97 with different chairs, and I don't think we've had an issue, but I also know that what our ranking members amendment does is just require the cooperation in the notice, because if the chair still wants to go forward with a subpoena that the ranking member disagrees with, then, you know, you call the committee and we have a vote. I just think it would, this amendment would make us more collegial, that we work together better, and I'm hoping that would set the tone for the rest of this Congress. So, but that's my 2 cents worth. Thank you.
Appreciate that. Are there other members seeking recognition on either side? If not, then the question before us is, should the amendment be adopted? The clerk will call the roll. Those supporting the amendment vote aye. Those nay. The clerk will call the roll.
Mr. Barton. Mr. Barton votes no. Mr. Upton. Mr. Upton votes no. Mr. Shimkus. Mr. Shimkus votes no. Mr. Murphy. Mr. Murphy votes no. Mr. Burgess. Mr. Burgess votes no. Ms. Blackburn. Ms. Blackburn votes no. Mr. Scalise. Mr. Latta. Mr. Latta votes no. Mrs. McMorris-Rogers. Mrs. McMorris-Rogers votes no. Mr. Harper. Mr. Harper votes no. Mr. Lance. Mr. Lance votes no. Mr. Guthrie. Mr. Guthrie votes no. Mr. Olson. Mr. Olson votes no. Mr. McKinley. Mr. McKinley votes no. Mr. Kinzinger. Mr. Kinzinger votes no. Mr. Griffith. Mr. Griffith votes no. Mr. Bilirakis. Mr. Bilirakis votes no. Mr. Johnson. Mr. Johnson votes no. Mr. Long. Mr. Long votes no. Mr. Bouchon. Mr. Bouchon votes no. Mr. Flores. Mr. Flores votes no. Mrs. Brooks. Mrs. Brooks votes no. Mr. Mullen. Mr. Mullen votes no. Mr. Hudson. Mr. Collins. Mr. Collins votes no. Mr. Kramer. Mr. Kramer votes no. Mr. Wahlberg. Mr. Wahlberg votes no. Ms. Walters. No. Ms. Walters votes no. Mr. Costello.
No.
Mr. Costello votes no. Mr. Carter. Mr. Carter votes no. Mr. Pallone. Mr. Pallone votes aye. Mr. Rush. Ms. Eshoo.
This wasn't in.
Ms. Eshoo votes aye. Mr. Engel.
Why do we mention that?
Mr. Engel votes aye. Mr. Green. Mr. Green votes aye. Ms. DeGette. Mr. Doyle. Mr. Doyle votes aye. Ms. Schakowsky. Ms. Schakowsky votes aye. Mr. Butterfield. Mr. Butterfield votes aye. Ms. Matsui.
But I thought
Ms. Matsui votes aye. Ms. Castor. Ms. Castor votes aye. Mr. Sarbanes. Mr. Sarbanes votes aye. Mr. McNerney. Mr. McNerney votes aye. Mr. Welch. Mr. Welch votes aye. Mr. Lujan. Mr. Lujan votes aye. Mr. Tonko. Mr. Tonko votes aye. Ms. Clark. Ms. Clark votes aye. Mr. Loebsack. Mr. Loebsack votes aye. Mr. Schrader. Mr. Schrader votes aye. Mr. Kennedy. Mr. Kennedy votes aye. Mr. Cardenas. Mr. Cardenas votes aye. Mr. Ruiz. Mr. Ruiz votes aye. Mr. Peters. Mr. Peters votes aye. Ms. Dingle. Ms. Dingle votes aye. Chairman Walden.
Walden votes no.
Chairman Walden votes no.
Is that good?
The clerk will report the tally.
Mr. Chairman, on that vote, there were 22 ayes and 29 noes.
The amendment is not approved. Are there other amendments? For what purpose, gentleman from New Jersey, seek recognition?
I have an amendment number 2. This deals with the rolling of the votes.
So on the postponement of the votes, we'll give our council time to find that amendment.
Amendment to the committee rules offered by Mr. Pallone.
Without objection, further reading of the amendment is dispensed with. The chair recognizes the gentleman from New Jersey to debate his amendment.
Thank you, Mr. Chairman. I'd like to offer an amendment to require the chair to obtain the concurrence of the ranking member prior to rolling or stacking votes on amendments. I see no reason why the rights of minority members to vote their views and prerogatives on legislation coming before the committee should be threatened. As I mentioned earlier in my opening remarks, my experience in the Natural Resources Committee showed me firsthand how constantly rolling votes led to less interaction between the parties during a markup. And less interaction leads to less bipartisanship and reduces the possibility for compromise. As far as I can tell in this committee's history, we have never thought it was necessary to adopt a rule to give the chairman authority to postpone votes and proceedings unilaterally, and it's unclear why such a significant break with precedent is now necessary. Now, again, this is a change in the rule from the previous Congress, and I just think it's going to make it much more contentious. I know the chairman has said he's not going to do this all the time, but the idea that you could do it without the concurrence of the ranking member, I think, does lend itself to the fact that we would have more and more rolling or stacking of the votes, which I don't think is helpful to the committee proceedings. I would yield back, Mr. Chairman.
Gentleman yields back the balance of his time. Chair recognizes himself in opposition to the amendment. This rule change was the subject of the colloquy we had earlier and a lot of discussion between our staffs and you and I together. As you know, the rule change would allow the chair of the committee or subcommittee to postpone a recorded vote without first seeking the concurrence of the ranking member, but it does require that the chair of the committee or subcommittee, as the case may be, consult with the ranking member prior to postponing the recorded vote, so there will be no surprise here. Further, the rule requires the committee provide reasonable notice of when the recorded vote will take place, so that all members on both sides of the aisle can be accommodated and can be here for the votes. Now, I've encouraged my members, and I'm sure you have yours, that we expect full participation in the markups, in the debates, in the hearings like we're having today. Everybody fights like the devil to get on this committee. I don't want threshold members that just come in and vote and leave. We're here to do the people's business, and I think that's why all of us signed up for this. And so I would hope you'd continue to participate, even if we roll the votes for the convenience of the members. We have a strong record of working closely in a bipartisan manner on this committee. Doesn't mean we're always going to agree on every policy issue, but we get our work done. We will continue to. So this is simply a tool of efficiency. I think in the last Congress, every other committee in the House with the exception of Armed Services and Budget, granted their chairs the authority to postpone the votes but us. So we're really the outlier here. I recognize, yield to the gentleman from Michigan, the former chair of the full committee.
Thank you, Mr. Chairman. I like the rule change that we have in the rules before us and would therefore oppose the amendment. I would just note that we do have a number of members on both sides of the aisle that are not only in leadership, but also have some pretty responsible positions on other committees as they have a waiver. I look at my good friend, and I say this, Mr. Elliott, who's ranking, I think, on Foreign Affairs Committee. So as we have other responsibilities and knowing that we don't want to miss votes, this is an opportunity that appropriate notice is given so that you know that there will be a series of votes that will start at a designated time. And I think that it's appropriate to make the change, particularly knowing that other committees share that same rule. So I would oppose the amendment and stand with my chairman.
Yeah, sure. I recognize and yield to the gentleman from New Jersey.
Mr. Chairman, I just, you know, I don't want to keep bringing up the Resources Committee, but I think that what has often happened in our committee is that, first of all, we're all here when we debate, or at least most of us are when we debate and then vote. If everyone knows, as in Resources, that they're just going to roll the votes at the end of the day or something of that nature, first of all, a lot of the members just don't show up. But beyond that, it has happened many times in this committee where after a debate, you know, we will decide that we can work something out, either by a change in an amendment or because everyone realizes that it's a good idea to maybe adopt the amendment. And it's just that give and take that we've had in this committee. It's not always, you know, sometimes it's between two Republicans, not necessarily between two Democrats or between Democrats and Republicans, that I just think has made this committee a little better than the others, frankly, and created an atmosphere of not only bipartisanship, but also doing things that are, you know, more substantive and meaningful. I just am very concerned. I know you're saying that you're not going to do this that often, but I just am very concerned that we not get into this practice where, you know, we just, you know, the members don't show up, we just roll everything at the end of the day, and we never had that kind of interaction that characterizes this committee, not only on a bipartisan basis, but, you know, just between members in general, that often leads to a substantive amendment or change that's adopted and that really is helpful. That is my plea. I'm really, I mean, I understand that I'm concerned about this as a minority member, but I'm also concerned about it just practically speaking in terms of what it results, the results in terms of what we adopt at a markup or you know, in full committee or subcommittee. I yield back.
And I yield back the balance of my time. Are there other members seeking recognition on this amendment? If not,
Yes, for roll call.
Gentleman asked for a roll call vote, and the clerk shall call the roll. Those in favor will vote aye, those opposed no, and the clerk will call the roll.
Mr. Barton? No. Mr. Barton votes no. Mr. Upton? No. Mr. Upton votes no. Mr. Shimkus? Mr. Shimkus votes no. Mr. Murphy? No. Mr. Murphy votes no. Mr. Burgess? Mr. Burgess votes no. Ms. Blackburn? Ms. Blackburn votes no. Mr. Scalise? No. Mr. Scalise votes no. Mr. Latta? No. Mr. Latta votes no. Mrs. McMorris-Rogers? Mrs. McMorris-Rogers votes no. Mr. Harper? Mr. Harper votes no. Mr. Lance? Mr. Lance votes no. Mr. Guthrie? No. Mr. Guthrie votes no. Mr. Olson? No. Mr. Olson votes no. Mr. McKinley? Mr. McKinley votes no. Mr. Kinzinger? Mr. Kinzinger votes no. Mr. Griffith? Mr. Griffith votes no. Mr. Bilirakis? Mr. Bilirakis votes no. Mr. Johnson? No. Mr. Johnson votes no. Mr. Long? Mr. Long votes no. Mr. Bouchon? No. Mr. Bouchon votes no. Mr. Flores? Mr. Flores votes no. Ms. Brooks? Ms. Brooks votes no. Mr. Mullen? Mr. Mullen votes no. Mr. Hudson? Mr. Collins? No. Mr. Collins votes no. Mr. Kramer? No. Mr. Kramer votes no. Mr. Wahlberg? Mr. Wahlberg votes no. Ms. Walters? Ms. Walters votes no. Mr. Costello? No. Mr. Costello votes no. Mr. Carter? Yes. Mr. Carter votes no. Mr. Pallone?
Votes aye.
Mr. Pallone votes aye. Mr. Rush? Ms. Eshoo? Ms. Eschew votes aye. Mr. Engel? Mr. Engel votes aye. Mr. Green? Mr. Green votes aye. Ms. DeGette? Mr. Doyle? Mr. Doyle votes aye. Ms. Schakowsky? Ms. Schakowsky votes aye. Mr. Butterfield? Mr. Butterfield votes aye. Ms. Matsui? Ms. Matsui votes aye. Ms. Castor? Mr. Sarbanes? Mr. Sarbanes votes aye. Mr. McNerney? Mr. McNerney votes aye. Mr. Welch? Mr. Welch votes aye. Mr. Lujan? Mr. Lujan votes aye. Mr. Tonko? Mr. Tonko votes aye. Ms. Clark? Ms. Clark votes aye. Mr. Loebsack? Mr. Loebsack votes aye. Mr. Schrader? Mr. Schrader votes aye. Mr. Kennedy? Mr. Kennedy votes aye. Mr. Cardenas? Mr. Cardenas votes aye. Mr. Ruiz? Mr. Ruiz votes aye. Mr. Peters? Mr. Peters votes aye. Ms. Dingle? Ms. Dingle votes aye. Chairman Walden?
Votes no.
Chairman Walden votes no. Mr. Chairman, on that vote, there were 21 ayes and 30 noes.
21 ayes, 31 noes. The amendment is not adopted. Okay, we're going to roll the rest of the votes till 9:30 tonight now, and just kidding, just kidding.
I knew you were going to do that.
For what purpose did gentleman from New Jersey seek recognition?
I was going to put the words in your mouth. Anyway, I have an amendment at the desk. This is the last one on the rule.
Can you hold a second?
Oh, sure.
I think we had the count different than I announced it. Is it 31-21, 21-31, or 21-30?
21 ayes, 30 nays.
Okay, I think I said 31. 21 ayes, 31 nays. Thank you. Now we'll 21 ayes, 30 nays. Sorry, the amendment's still not adopted. Gentleman has an amendment at the desk. Is that right?
Yes, this is the amendment on witness disclosures, and this is the last one on the rules package, Mr. Chairman.
All right. Clerk will report the amendment.
Amendment to the committee rules offered by Mr. Pallone.
Without objection, the further reading of the amendment is dispensed with, and the chair recognizes the gentleman from New Jersey on his amendment.
Thank you, Mr. Chairman. My amendment is simple. It would require any presidential appointee invited to testify before this committee to disclose conflicts of interest directly related to the subject of that hearing. Potential conflicts of interest of government officials are an increasing concern to the American people, and my amendment would provide much-needed transparency in our hearings. Several of the President's recent nominations to his administration have come under scrutiny for serious potential conflicts of interest, issues that could directly affect their work, and this is a troubling pattern that I think our committee must address. Although high-level government officials are required to file financial disclosures under federal law, these disclosures only happen once a year and thus are, in my opinion, under-inclusive. My amendment would ensure that a presidential appointee testifying before our committee would be required to disclose any current conflicts at the time of the hearing. I think taxpayers have a right to know whether these presidential officials have a personal or financial interest in the outcome if they make recommendations or testify on issues before this committee. The amendment would also allow for this requirement to be waived if both the committee chairman and ranking member determine there is good cause to do so, and this should address any hesitation members may have about the amendment. The amendment would ensure fairness and transparency on these issues, and I urge my colleagues to vote in favor of it. I yield to the gentleman from Maryland, Mr. Sarbanes.
Thank the gentleman for yielding. I think it's hard to overstate the point Mr. Pallone made a moment ago, which is the heightened expectation that the public now has that anyone who appears here in Congress, whether they're appearing as an appointee who's seeking confirmation or whether they're appearing before a committee like ours, there should be absolute transparency and disclosure of any potential conflicts of interest that they might bring at the time of their testimony. And this we can regard as a situation of changed circumstances. It's over the last few years, for a variety of reasons, that the public has become much more anxious about the question of whether their interests are being safeguarded or whether other interests are kind of winning the day. And so the expectation that these conflicts will be divulged at the time anyone appears here to testify before us, I think, is very high. And it would behoove the committee, I think it would it'd be in keeping with the standards of this committee to put that requirement in place, and I thank the gentleman for his proposed amendment to the rules and yield back to him.
Thank you. And I yield back the balance of my time, Mr. Chairman.
Gentleman yields back the balance of his time. Chair recognizes himself in opposition to the amendment. As you may recall, in the last Congress, we updated our Committee Rule 3 to conform it to the changes that were made in the House Rule pertaining to witness disclosures. The House Rule and the Committee Rule were revised to require information in the witness disclosure relating to foreign government contracts or payments. When we revised this rule 2 years ago, no members of the committee filed amendments at our organizational meeting. Now, however, we do have these amendments seeking to extend the witness disclosure requirements we apply to non-governmental witnesses to governmental witnesses who appear before the committee. First of all, I think it's important to note for the record the top 67 political appointees already file with the Office of Government Ethics. Their information is already publicly available on the website once they file. The other officials, including at the SES rank, also file ethics statements, and there is a fairly simple process to get those if members want them. I think it's important to consider the rationale of why we require disclosures for non-governmental witnesses and do not for governmental witnesses. The entire body of federal law and common law governs conflicts of interest for government employees already. The same is not true for private citizens with regard to their employment. Already, high-level officials in the government are required to file annual public disclosure documents, much like the ones members file. This includes assets held for income, stocks, bonds, and other income-producing assets. Again, this public disclosure requirement applies to all high-level officials and officers or employees who are GS 15 or above. These reports are filed with agency ethics officers and for high-level officials, and they are posted on the Internet. So in preparing for our hearings, this information is already available if you want it. It's available publicly, and you can access it for any of these witnesses. So if anyone on the committee has concerns about a witness and purported conflicts of interest, that member can use his or her 5 minutes at any hearing if they choose to ask questions about this information. I would encourage my members to vote no on this amendment as it is unnecessary. And yield back the balance of my time. Are there other members seeking recognition? If not, then the question arises on passage of this amendment. Those supporting the amendment will vote aye. Those opposed, no, and the clerk will call the roll.
Mr. Barton. No. Mr. Barton votes no. Mr. Upton. No. Mr. Upton votes no. Mr. Shimkus. Mr. Shimkus votes no. Mr. Murphy. Mr. Murphy votes no. Mr. Burgess. Mr. Burgess votes no. Ms. Blackburn. Ms. Blackburn votes no. Mr. Scalise. Mr. Scalise votes no. Mr. Latta. Mr. Latta votes no. Mrs. McMorris-Rogers. Mrs. McMorris-Rogers votes no. Mr. Harper. Mr. Harper votes no. Mr. Lance. Mr. Lance votes no. Mr. Guthrie. Mr. Guthrie votes no. Mr. Olson. Mr. Olson votes no. Mr. McKinley. Mr. McKinley votes no. Mr. Kinzinger. Mr. Kinzinger votes no. Mr. Griffith. Mr. Griffith votes no. Mr. Bilirakis. Mr. Bilirakis votes no. Mr. Johnson. Mr. Johnson votes no. Mr. Long. Mr. Long votes no. Mr. Bouchon. Mr. Bouchon votes no. Mr. Flores. Mr. Flores votes no. Ms. Brooks. Ms. Brooks votes no. Mr. Mullen. Mr. Mullen votes no. Mr. Hudson. Mr. Collins. Mr. Collins votes no. Mr. Kramer. Mr. Kramer votes no. Mr. Wahlberg. Mr. Wahlberg votes no. Ms. Walters. Ms. Walters votes no. Mr. Costello.
No.
Mr. Costello votes no. Mr. Carter. Mr. Carter votes no. Mr. Pallone.
Votes aye.
Mr. Pallone votes aye. Mr. Rush. Ms. Eshoo. Ms. Eshoo votes aye. Mr. Engel. Mr. Engel votes aye. Mr. Green. Ms. DeGette. Mr. Doyle. Mr. Doyle votes aye. Ms. Schakowsky. Ms. Schakowsky votes aye. Mr. Butterfield. Mr. Butterfield votes aye. Ms. Matsui. Ms. Matsui votes aye. Ms. Castor. Ms. Castor votes aye. Mr. Sarbanes. Mr. Sarbanes votes aye. Mr. McNerney. Mr. McNerney votes aye. Mr. Welch. Mr. Welch votes aye. Mr. Lujan. Mr. Lujan votes aye. Mr. Tonko. Mr. Tonko votes aye. Ms. Clark. Ms. Clark votes aye. Mr. Loebsack. Mr. Loebsack votes aye. Mr. Schrader. Mr. Schrader votes aye. Mr. Kennedy. Mr. Kennedy votes aye. Mr. Cardenas. Mr. Cardenas votes aye. Mr. Ruiz. Mr. Ruiz votes aye. Mr. Peters. Mr. Peters votes aye. Ms. Dingle. Ms. Dingle votes aye. Chairman Walden.
Walden votes no.
Mr. Walden votes no.
Are there any members who did not cast a vote, seeking a cast a vote? Mr. Green?
Mr. Green votes aye.
Are there other members wishing to be recorded? Seeing none, the clerk will report the roll.
Mr. Chairman, on that vote, there were 22 ayes and 30 noes.
This vote, 22 ayes, 30 noes. The amendment is not agreed to. Are there further amendments to the rules package? Seeing none, if there are no further amendments, the question now becomes adopting on the resolution. Yeah. Those in favor will say aye. Those opposed, nay. The ayes appear to have it. The ayes have it, and the resolution is agreed to. I just want to restate again so everybody's clear in our colloquy Ms. Eshoo and I had about members being able to sit in on the other subcommittees. I think that's always how we've operated. I've found it beneficial, and we'll continue that practice to accommodate our members. Now that our rules have been adopted and pursuant to Rule 4 of those rules, I'd like to introduce the new Vice Chair of the committee for the 115th Congress, the former chairman of this great committee, the gentleman from Texas, Mr. Joe Barton. Mr. Barton, as you know, yeah, we'll work on that. We're all familiar with the great things he accomplished during his chairmanship and his dedication to this committee and its traditions and successes. And I want to thank Joe for agreeing to serve as my vice chair. Your good counsel, your support will be invaluable to me as we work to tackle the many issues before us here in the Congress. As you know, you will have a major role to play, especially on policy in the energy environment, in the energy world. And I thank you for taking a leadership role in that as a member, not only as vice chair of the full committee, but a member of the subcommittee on energy. And so, Joe, welcome as our vice chair. We appreciate it. We'll now consider a resolution establishing the jurisdiction of the Energy and Commerce Committee's subcommittees. The chair has a resolution at the desk and asks the clerk to report.
A resolution offered by Mr. Walden.
Without objection, further discussion of the resolution is dispensed with, and the chair recognizes himself for 5 minutes. We made one change to the subcommittee jurisdictions in this Congress, and this change affects the jurisdiction of the Subcommittee on Energy, formerly known as the Subcommittee on Energy and Power, and the Subcommittee on Environment, formerly known as Subcommittee on Environment and the Economy. In the previous Congress, matters related to the Clean Air Act were referred to the Subcommittee on Energy. In this Congress, we are moving the Clean Air Act from the Subcommittee on Energy to the Subcommittee on the Environment. Further, the amended jurisdictional statement that we are considering today clarifies that matters relating to air contamination, in addition to soil and water contamination, will be within the jurisdiction of the Subcommittee on the Environment. The jurisdictions of the other Energy and Commerce subcommittees remain the same. Finally, we have one additional name change. The Subcommittee on Commerce, Manufacturing, and Trade will now be called the Subcommittee on Digital Commerce and Consumer Protection. Is there further discussion of the resolution? The question now occurs on the resolution. All those in favor will say aye. Aye. Those opposed, nay. The ayes have it. The ayes appear to have it, and the resolution is agreed to. We will now consider a resolution appointing the subcommittee chairs, vice chairs, and designated subcommittee members. The chair has a resolution at the desk. Asks the clerk to report.
A resolution offered by Mr. Walden.
Without objection, the reading of the resolution is dispensed with, and the chair recognizes himself briefly. The resolution simply designates the chair and vice chair of each subcommittee, and the resolution also designates the Republican members of each subcommittee. I'm excited to have 4 new Republican members joining our subcommittees and thank my Republican colleagues for agreeing to serve in these positions. We do have an ambitious schedule ahead of us in this Congress, and I look forward to working side by side with you. Is there further discussion of the resolution? If there's no further discussion, the vote occurs on the resolution. All those in favor will say aye. Aye. Those opposed, nay. The ayes appear to have it. The ayes have it, and the resolution is agreed to. Now, recognize the gentleman from New Jersey who has a resolution at the desk. The clerk will report.
A resolution offered by Mr. Pallone.
Thank you, Mr. Chairman. I offer a resolution designating the subcommittee ranking members and the Democratic subcommittee membership for the 115th Congress. I'm very pleased that our Democratic caucus has selected the following ranking members of the subcommittees: Communications and Technology, Mike Doyle; Digital Commerce and Consumer Protection, Jan Schakowsky; Energy, Bobby Rush; Environment, Paul Tonko; Health, Jean Green; and Oversight and Investigations, Diana DeGette. This is a very strong leadership team, and I look forward to working with them. I would point out, as I'm sure you noticed, that Mike Doyle is now the ranking member for Communications and Technology, takes over from Anna Eshoo, and I do want to say that we're very I just want to comment about Anna Eshoo's long tenure as the ranking member of the subcommittee, and I guess chairwoman at one time, correct or not? All right. But in any case, she has always been kind of, I guess the best thing to say is the innovation person, not only of this committee, but of our Democratic caucus in general. And I know she's going to continue to be active, but I did want to say that we're very, we want to comment on the fact that her tenure was so successful, in particular when it came to the innovation agenda, which I admire the most, Anna, so thank you. And so I would, yes. And so I would yield back to you, Mr. Chairman, for consideration of the Democratic resolution.
Gentleman yields back. I'm going to just recognize myself for a minute on your resolution to commend Ms. Eshoo for her many years of service and her great inspirational ideas about innovation, technology, broadband, all the things we've been able to work side by side on over the years. We've passed some pretty important legislation that's still playing out to make more broadband available, wireless spectrum available, generate revenue for first responder programs, as well as the taxpayers pay down debt. And it's been a great joy to work side by side with you on the Communications and Technology Subcommittee. I know Ms. Doyle will do a great job. Of course,
I'd respond by saying thank you. Just an enormous and deep thanks, both to our ranking member for his generous comments, and to you, Mr. Chairman. It's a source of pride to me to see you become chairman of the full committee. And I salute Fred, who has always been a friend, comported himself with such dignity, and to Joe Barton, who has been a friend for all the years that I've been on the committee. I chose to term limit myself, in case my Republican colleagues don't know this. You have a different system. I think that I'd like to see my side open up more. And so while my colleagues gave me a great gift when they elected me to be the ranking member of the subcommittee, which I love, and I'm not going anywhere. I'm still going to be on the subcommittee. And I think you all know that I'm still going to keep my voice out there, right? That we should be making room for others. And I have great confidence in Mike Doyle, the members of the subcommittee. I love energy and commerce. I'm proud of what we've done together. I know that we have a lot of challenges ahead of us, and I hope that the rocky times won't obliterate the opportunities to get other things done.
Hear, hear.
So with that, really, all of my thanks to you. I couldn't mean it more.
Thank you. And I'll yield back the balance of my time. Is there any further discussion on the resolution? Seeing none, all those in favor will say aye. Those opposed, nay. The ayes have it, and the resolution is agreed to. Chair recognizes himself to announce a number of policies that will observe this Congress. For our committee, veterans, many of these will sound familiar to you, although I have 2 additions. During the last Congress, we continued our tradition or transition, that is, to paperless hearings by electronically distributing testimony at all of the committee hearings. We're going to continue this policy under my chairmanship. For members who are more comfortable with paper copies of testimony, we will continue to work with you to accommodate your needs. This change has helped our committee budget and improved our efficiency, and I thank the members for their support of this policy. Second, a policy on participation at subcommittee hearings of which you are not a member. This policy has been referred to as the SU Protocol, named for my former ranking committee on the C&T sub, Anna Eshoo. By right, all members of the House are entitled to non-participatory attendance at hearings if they're not on the committee. For members of the Energy and Commerce Committee, however, you may question witnesses at a hearing even if you are not on the subcommittee, but you will be recognized only after all the members of the subcommittee have been recognized, Democrat and Republican, regardless of when they arrived at the hearing. So you get to participate, you get to ask questions, but you're the last one after all the members of the subcommittee have had their opportunity. I would ask that members not abuse this privilege. We all have busy schedules, and it can be frustrating when a member that is not on the subcommittee, has not been present for the majority of the hearing, shows up at the last second to ask questions. If you want to participate and ask questions, I think you should attend the majority of the hearing if you can. On a related note, I would like to encourage that all members be prompt to show up on time for hearings and markups. This is a courtesy both to our witnesses and to your fellow members. As you all know, we keep an ambitious schedule. Most mornings, 2 subcommittee hearings are going on at the same time, so the members can be recognized as present at the gavel for purposes of establishing order of recognition. It's important that the hearings start at the noticed time. It's my expectation that, absent exceptional circumstances, we're starting our hearings promptly at the time noticed. In addition, I'd like to discuss some of my policies with regard to markups. During markups in Chairman Upton's tenure, bipartisan amendments were given priority recognition. I intend to continue that tradition in this Congress. I encourage members to work on both sides of the aisle and work together to bring bipartisan amendments to our committee. Finally, a word of caution for anyone drafting bills or amendments. The Majority Leader follows several protocols in scheduling legislation for the floor. And while these protocols are non-binding on the committee, I would encourage you to observe the protocols in drafting the legislation. That is that. Now, we'll now consider a resolution adopting the committee oversight plan. The chair has a resolution at the desk and asks the clerk to report.
Authorization and Oversight Plan of the Committee of Energy and Commerce, U.S. House of Representatives, 115th Congress.
Without objection, the resolution is dispensed with. The chair recognizes himself for 5 minutes. The rules of the U.S. House require each committee to adopt an authorization and oversight plan and to submit it to the Committee on Oversight and Government Reform and the Committee on House Administration by February 15th. The House rules adopted earlier this month made one change to what was previously known as the oversight plan. We must now include in this document the committee's plan to address lapsed or expired authorizations in its jurisdiction. That agenda is set forth in the last section of this document. We have a number of expired authorizations that we're going to begin to examine in this Congress. Mr. Pallone, it's my hope that we can work together to prioritize the reauthorization work before this committee. With regard to the committee's oversight agenda, as a former ranking member of the Subcommittee on Oversight and Investigations, I can speak personally about how integral this work of the Oversight Subcommittee is to the committee's success. When oversight is properly done, it creates the factual record that informs our committee's legislative solutions and allows us to develop the right fixes for the problems that we find. We have talked a lot today about this committee's great traditions, and one of them has been the strength of its oversight. I believe we have used our authorities appropriately to examine federal programs and compliance with federal regulations and policies, and I commit as chairman to upholding that same tradition. I'll also note that our most successful investigations have often been the ones that enjoy bipartisan support, and I hope we can work together in exercising our appropriate oversight authorities. The oversight plan for the 115th Congress proposed today outlines some of the topics and matters of which this committee intends to conduct oversight. To be clear, this plan does not limit in any way the matters that we can look into. The committee enjoys broad jurisdiction, which includes the most important policy issues and debates facing our country today. From oversight of health insurance markets, critical infrastructure and cybersecurity, drug safety and innovation, electricity markets and transmission, the management of federal agencies and departments and automobiles, to name just a few. We will not have a shortage of subjects to examine. We will review these programs to be sure they're managed appropriately and consistent with congressional intent. Ranking Member Pallone will offer some remarks shortly and possibly some amendments. I believe the oversight plan for this Congress is comprehensive and well-balanced among our jurisdictions. I believe this plan is consistent and in many respects similar to the oversight plans adopted in previous Congresses that enjoyed minority support in terms of the subject matter and the scope of the plan. I hope the minority will support this plan as well. Therefore, I'd urge a yes vote on the oversight plan. I look forward to its adoption. And now I recognize my friend from New Jersey for 5 minutes.
Thank you, Mr. Chairman. This authorization and oversight plan really shows the broad jurisdiction of this committee that we have over many of the critical issues before our nation. And since this plan outlines the areas where this committee is going to focus its oversight attention, I would have hoped that you and I and our staffs could have come to an agreement on the oversight priorities of the next 2 years so that this plan was a truly bipartisan one. There is a lot in this plan that I agree with, but there are some major glaring omissions that simply should not and cannot be ignored. My Democratic colleagues and I will be offering several amendments this afternoon to strengthen it. The Energy and Commerce Committee is going to be at the forefront of the various debate, I should say, of the vigorous debate on the majority's efforts to repeal the Affordable Care Act. If this is really the majority's intent, you would think that they would want to look at the impacts repeal would have on the American people. The oversight plan does not mention anything about the consequences of repealing the Affordable Care Act. The majority's oversight plan also does not properly address some of the major threats to climate change and the environment that we're likely to experience with the Trump administration. There is no recognition of the fact that the Paris Agreement on climate change became international law in November, and that's another glaring omission. The United States led this effort, and that leadership should continue as we collectively work to fight climate change while also continuing to build a clean energy economy. There are other areas that are not either properly addressed or even included in this plan, and my colleagues and I will be introducing amendments to strengthen it so that we can build a stronger economy, create more good-paying jobs, and protect consumers. And I yield back.
Gentleman yields back. Is there further discussion on the resolution?
Well, we'd have some amendments at this
All right.
time.
Are there bipartisan amendments to the resolution? Are there other amendments?
Mr. Chairman? No.
Pardon me? Who's seeking recognition? Oh, yes, Mr. Engel.
Mr. Chairman, I have an amendment at the desk.
The clerk will report the amendment.
Amendment to the draft oversight plan offered by Mr. Engel.
Chair recognizes the gentleman from New York for 5 minutes to discuss his amendment.
Thank you very much, Mr. Chairman. I appreciate it. My amendment applies to the climate change section of the majority's oversight plan, which does not say anything about how our national energy policy should prevent or mitigate the effects of climate change. This is obviously one of the most important issues within the committee's jurisdiction and certainly deserves our attention. So my amendment would add language to ensure that the committee considers actions needed to meet our obligations under the Paris Agreement. The Paris Agreement marks a historic moment in the fight against climate change by establishing a strong global consensus to reduce carbon pollution and set the world on the path to a clean energy future. For the agreement to go into effect, 55 countries representing 55% of global emissions had to formally join. And last November, the world crossed the threshold needed to bring the Paris Agreement into force more than 3 years ahead of schedule. But this significant milestone in global cooperation on climate action is missing from the majority's oversight plan. So, Mr. Chairman, this should not be a partisan issue. This is an important issue, and we need to work together on it. We have an opportunity to implement policies that encourage American businesses to invest in new technologies and drive innovation. Since the committee is tasked with conducting oversight on issues related to a national energy policy and shares jurisdiction with the Foreign Affairs Committee over global climate change, we should ensure our oversight plan includes actions associated with the Paris Agreement. To ignore such a large component of energy and climate policy would be an unfortunate mistake, so I urge all members to support my amendment. And I yield back.
Gentleman yield back this time. Chair recognizes the Chairman of the Environment Subcommittee, Mr. Shimkus, for 5 minutes.
Thank you, Mr. Chairman. I seek time in opposition to the amendment.
The purpose of this meeting is to vote today on the Oversight Plan, which already includes provisions relating to this international agreements. The committee included in the document its plans to continue to monitor international negotiations on efforts to control greenhouse gas emissions in connection with concerns about global climate change. In the coming Congress, we plan to continue to monitor international negotiations, including relating to actions taken under the United Nations Framework Convention on Climate Change, including any actions taken with regard to the Paris Agreement. As we implement our agenda, we will continue to have many hearings, and the minority will have the opportunity, as always, to offer witnesses who may help educate the members on these important issues. We remain focused on economic and job growth and the impacts of federal policies on American consumers, and we look forward to working with you. I urge a no vote on this amendment, and I yield back my time.
Gentleman yields back, balances time. Are there other members seeking recognition on this amendment? Chair recognizes gentleman from New Jersey.
Thank you, Mr. Chairman. I'll be brief. I strongly support the Engel Amendment because I think it is important to ensure that the committee addresses actions needed to meet the U.S. obligations under the Paris Agreement. In other words, recognizing that the Paris Agreement is, in fact, in force. And obviously, many of us are concerned because we've heard comments during the course of the last few months by the President suggesting that he might even abrogate the Paris Agreement. And I think there's no question in our mind that, this is something that is in force, should not be abrogated, cannot be abrogated. And so to that end, I just wanted to say, Mr. Chairman, many members of this committee have received a letter signed by over 630 business leaders and investors reaffirming their deep commitment to addressing climate change and urging all U.S. elected leaders to strongly support the Paris Agreement. And these forward-looking corporate leaders do not represent liberal or progressive interests, but rather they understand the danger that unchecked climate change poses to their businesses and livelihoods. And they also understand that transition to a clean, renewable energy economy will help their bottom line while also creating jobs. This letter, which is addressed to then President-elect, now President Trump, and members of Congress, states, and I quote, "Implementing the Paris Agreement will enable and encourage businesses and investors to turn billions of dollars in existing low-carbon investments into the trillions of dollars the world needs to bring clean energy and prosperity to all." So again, I urge my colleagues to support this common-sense amendment so that we can help create jobs, protect the public health, mitigate the worst impacts of climate change, and promote our national security. I yield back.
Gentleman yields back. Are there other members seeking recognition? Seeing none, the vote now occurs on the Engel Amendment. Those in favor will say aye. Roll call.
Aye.
Those opposed, no.
Mr. Chairman, I ask for a roll call recorded vote, please.
The gentleman from New York's asked for a roll call vote. The clerk will call the roll.
Mr. Barton. Mr. Barton votes no. Mr. Upton. Mr. Upton votes no. Mr. Shimkus. Mr. Shimkus votes no. Mr. Murphy. Mr. Murphy votes no. Mr. Burgess.
Yeah.
Mr. Burgess votes no. Ms. Blackburn. Mr. Scalise. Mr. Latta. Mr. Latta votes no. Mrs. McMorris-Rogers. Mrs. McMorris-Rogers votes no. Mr. Harper. Mr. Harper votes no. Mr. Lance. Mr. Lance votes no. Mr. Guthrie. Mr. Guthrie votes no. Mr. Olson. Mr. Olson votes no. Mr. McKinley. Mr. McKinley votes no. Mr. Kinzinger. Mr. Kinzinger votes no. Mr. Griffith. Mr. Griffith votes no. Mr. Bilirakis. Mr. Bilirakis votes no. Mr. Johnson. Mr. Johnson votes no. Mr. Long. Mr. Long votes no. Mr. Bouchon. Mr. Bouchon votes no. Mr. Flores. Mr. Flores votes no. Mrs. Brooks. Mrs. Brooks votes no. Mr. Mullen. Mr. Mullen votes no. Mr. Hudson. Mr. Collins. Mr. Collins votes no. Mr. Kramer. Mr. Kramer votes no. Mr. Wahlberg. Mr. Wahlberg votes no. Mrs. Walters. Mrs. Walters votes no. Mr. Costello.
No.
Mr. Costello votes no. Mr. Carter. Mr. Carter votes no. Mr. Pallone.
Votes aye.
Mr. Pallone votes aye. Mr. Rush. Ms. Eshoo. Ms. Eshoo votes aye. Mr. Engel. Mr. Engel votes aye. Mr. Green. Mr. Green votes aye. Ms. DeGette. Mr. Doyle. Mr. Doyle votes aye. Ms. Schakowsky. Mr. Butterfield. Ms. Matsui. Ms. Matsui votes aye. Ms. Castor. Ms. Castor votes aye. Mr. Sarbanes. Mr. Sarbanes votes aye. Mr. McNerney. Mr. McNerney votes aye. Mr. Welch. Mr. Welch votes aye. Mr. Lujan. Mr. Lujan votes aye. Mr. Tonko. Mr. Tonko votes aye. Ms. Clark. Ms. Clark votes aye. Mr. Loebsack. Mr. Loebsack votes aye. Mr. Schrader. Mr. Schrader votes aye. Mr. Kennedy. Mr. Kennedy votes aye. Mr. Cardenas. Mr. Cardenas votes aye. Mr. Ruiz. Mr. Ruiz votes aye. Mr. Peters. Mr. Peters votes aye. Ms. Dingle. Ms. Dingle votes aye. Chairman Walden.
No.
Chairman Walden votes no.
Are there other members wishing to be recorded? The gentlelady from Tennessee.
Mrs. Blackburn. Mrs. Blackburn votes no.
Mr. Chairman, how am I recorded?
How's Mr. Hudson recorded?
Mr. Hudson is not recorded.
No.
Mr. Hudson votes no.
Mr. Butterfield.
Mr. Butterfield votes aye.
Are there other members not recorded who wish to be recorded? Seeing none, clerk will report the tally.
Mr. Chairman, on that vote, there were 21 ayes and 30 noes.
21 ayes, 30 noes. The amendment is not adopted. For what purpose, gentlelady from Florida seek recognition?
Mr. Chairman, I ask unanimous consent to consider en bloc the following amendments: the Castor Amendment, Eschew, McNerney, and Peters.
The clerk will report.
An en bloc amendment offered by Ms. Castor.
With unanimous consent, we'll dispense with further reading of the amendment. The chair recognizes gentlelady from Florida.
Thank you, Mr. Chairman. Colleagues, my amendment goes to the intersection of the committee's jurisdiction on climate change, public health, and the environment. There is a growing urgency to address the impacts of the changing climate, and we have a clear moral responsibility to future generations to do all that we can to understand the impacts and develop solutions together. Last year was the warmest year on record. That was the third consecutive time that happened. 16 out of the 17 hottest years have all occurred since the year 2000. And I believe that working together, we can develop solutions. Now, I represent the state of Florida. We have a lot of economic and environmental impacts already underway because of the changing climate. But we need to focus here, add some language to our oversight plan relating to public health. We've already seen significant impacts due to rising temperatures, not to mention mosquito-borne disease, infectious diseases, waterborne illnesses. A report by the bipartisan group called Risky Business last year said that regarding the heat, unmitigated climate change is expected to lead to increasing heat during the 21st century and will be the primary catalyst for higher mortality. And Florida will likely have among the nation's highest death tolls as a result of higher temperatures driven by climate change. But no area in the country is immune. Residents of the southeastern United States currently endure about 8 days of temperatures at or above 95 degrees Fahrenheit every day. They think over this century we're going to face an additional 48 to 130 days of increased heat. Of course, you all know that higher temperatures contribute to the formation of harmful air pollutants and allergens. My amendment would expand the committee's ability to examine the respiratory and cardiovascular impacts of climate change, especially for the most vulnerable populations. The American Lung Association says that inhaling smog pollution is like getting a sunburn on your lungs. This is particularly critical that we do this for our children. They're outside more often, they're taking deeper breaths. Regarding more vulnerable communities, the NAACP says that 75% of African Americans live in counties that currently violate federal air pollution standards, and the Environmental Defense Fund found that our Latino neighbors are 3 times more likely to die from asthma, often for those same reasons. I believe we have the talent at our fingertips in this country to tackle the impacts of the changing climate, particularly relating to our health. One of those talented folks is Dr. Ruiz, who's just come on to the committee, and I'd like to yield the balance of my time to Dr. Ruiz.
Thank you very much. Climate determines the habitat of animals and disease-carrying vectors. Some viruses thrive in warmer weather, and we have seen increases in infections and geospatial spread of viruses like the Zika virus. In 2016, there were 4,900 cases of Zika infections in the continental United States and 35,527 in U.S. territories. In addition to the West Nile, the arid conditions could also increase the number of cases of valley fever, a potentially fatal disease caused by a fungus called coccidioides that can grow in the soil and becomes airborne if the soil dries out. While the majority of people exposed to the spores do not exhibit symptoms, people who start to develop the disease can have cough, fever, headache, and in rare cases, it can lead to death. Therefore, whether you believe it was man-made or not, the weather is becoming warmer in northern America, and we are seeing the spread of these vector-borne illnesses, and we should start to provide oversight and investigate the possibilities of how we can mitigate those public health crises on our human health. Thank you very much. I yield back my time.
Gentleman yields back time. Are there other members seeking recognition? It's in block, right? So if there are other members seeking, Mr. McNerney. Chair recognizes gentleman from California, Mr. McNerney, for 5 minutes. Mr. McNerney, can you turn on your microphone, please?
I did, thanks. My amendment would have the committee investigate if the administration intimidates climate scientists or extinguishes climate data. It also requires the committee to seek ways to have the administration use unbiased science in decision-making. I propose this amendment in response to statements the new administration has made and actions taken on climate. Climate change is happening, and it's a serious threat. It will add billions of dollars of cost to make our nation's infrastructure more resilient. Our military leaders recognize the threat of climate change to our national security. Sea levels will rise, which is a threat to low-lying areas like my communities. This committee's oversight plan fails to address this and many other threats, and instead looks to attack the Paris Agreement, signed by more than 70 countries, and to overturn federal actions on climate change, such as the Clean Power Plan. We should be working to strengthen scientific information used by federal agencies. Unfortunately, nothing the new administration has said shows any concern for the realities and threats of climate change. We've even seen mentions of climate change removed from the White House website. Just the other day, the CDC Summit on Health and Climate Change was canceled. Numerous peer-reviewed studies shows that 97% of climate scientists agree that climate warming trends are extremely likely to be due to human activities. My amendment is needed to ensure that climate change is not ignored. I urge my colleagues who believe that climate change is happening and is caused largely by human activities, and that we still have a chance of preventing the worst impacts of climate change, to support this amendment. Mr. Chairman, I yield back.
Gentleman yields back balance of his time. Chair, are there other members seeking recognition? Gentleman from California, Mr. Peters, recognized for 5 minutes.
Thank you very much, Mr. Chairman. My amendment would ensure that the Energy and Commerce Committee addresses the threat of climate change, following examples set by the defense community to mitigate climate change, strengthen resiliency, and promote domestic energy security. The DoD is using renewable energy to make our military more powerful, efficient, and effective, because they know that energy security is national security, and the idea of climate change as a national security threat is just as relevant to this committee and has implications beyond harm to the environment. In 2015, the Department of Defense released a report that said, quote, "Climate change is an urgent and growing threat to national security, contributing to an increased natural disasters, refugee flows, and conflicts over basic resources such as food and water." As a result of these security threats, the Department has devised a series of practices that are of more general usefulness and from which this committee could take some lessons. For instance, major power outages are increasingly jeopardizing critical mission operations as they are growing in number and severity across the United States. To address this, military installations in San Diego and across the country are investing in renewable energy, building energy resiliency, and assuring energy security, all while achieving savings on energy purchases. At Marine Corps Base Camp Pendleton, systems of solar panels and microgrids provide a renewable backup energy supply in the event of a power outage. Naval Base Coronado commissioned the largest renewable energy purchase by the federal government in history, which will provide 210 megawatts of energy and an estimated $90 million in savings over the length of the contract. And a hybrid renewable energy project that broke ground at Fort Hood, Texas last January is projected to save the Army a minimum of $168 million over the course of the contract. All of these large-scale renewable energy projects are developed using third-party financing through existing authorities such as power purchase agreements and enhanced use leases, with deals structured to be cost-neutral or with savings. Since 2009, the Department estimates it has saved over $1 billion through renewable energy purchases or projects on installations. So incorporating climate change into adaptation and resiliency plans is a forward-looking, smart approach the military is taking to bolster national security, and we can learn from the military's successes and best practices and collaborate on future renewable energy projects in the rest of the federal government. I urge my colleagues to support this amendment so that this committee can confront climate change as a threat to national security, expand renewable energy research, and promote domestic energy security. Thank you, Mr. Chairman. I yield back my time.
Thank the gentleman. He yields back the balance of his time. Other members seeking recognition. Gentleman from Illinois, Mr. Shimkus, is recognized.
Thank you, Mr. Chairman, to speak in opposition to the amendment. The amendments are unnecessary. The plan already includes broad provisions regarding oversight relating to global climate change. The committee has included in this document its plans to consider whether international agreements and regulatory efforts addressing climate change are scientifically well-grounded. The committee included in this document plans to review the activities undertaken in the area of climate change, including DOE, HHS, and other agencies within the committee's jurisdiction, including efforts to prepare for and respond to weather events and natural disasters in the future. Our oversight, consistent with our jurisdiction, should focus on impacts of regulations and policies on Americans, and this plan does so. Over the past 3 Congresses, the committee held 21 hearings relating to EPA's climate regulations. In 2013, we invited 13 federal agencies to testify on climate change policies and activities, including the Science Advisor, NOAA, NASA, and others, but all but 2 agencies, EPA and DOE, declined to testify. As we implement our agenda, we will continue to have many hearings, and the minority will have the opportunity, as always, to offer witnesses who may help educate the members on these important issues. We remain focused on job creation and growing our economy, and we look forward to working with you, and I urge a no vote on this amendment, and I yield back my time.
Gentleman yield back balance his time. Other members seeking recognition? If there are no other members seeking recognition, the question now comes on the en bloc amendments. Those in favor will say aye. Those nay, the clerk will call the roll.
Mr. Barton. Mr. Barton votes no. Mr. Upton. Mr. Upton votes no. Mr. Shimkus. Mr. Shimkus votes no. Mr. Murphy. Mr. Murphy votes no. Mr. Burgess. Mr. Burgess votes no. Ms. Blackburn. Mrs. Blackburn votes no. Mr. Scalise. Mr. Latta. Mr. Latta votes no. Mrs. McMorris-Rogers. Mrs. McMorris-Rogers votes no. Mr. Harper. Mr. Harper votes no. Mr. Lance. Mr. Lance votes no. Mr. Guthrie. Mr. Guthrie votes no. Mr. Olson. Mr. Olson votes no. Mr. McKinley. Mr. McKinley votes no. Mr. Kinzinger. Mr. Kinzinger votes no. Mr. Griffith. Mr. Griffith votes no. Mr. Bilirakis. Mr. Bilirakis votes no. Mr. Johnson. Mr. Johnson votes no. Mr. Long. Mr. Long votes no. Mr. Bouchon. Mr. Bouchon votes no. Mr. Flores. Mr. Flores votes no. Ms. Brooks. Ms. Brooks votes no. Mr. Mullen. Mr. Mullen votes no. Mr. Hudson. Mr. Hudson votes no. Mr. Collins. Mr. Kramer. Mr. Kramer votes no. Mr. Wahlberg. Mr. Wahlberg votes no. Ms. Walters. Ms. Walters votes no. Mr. Costello. No. Mr. Costello votes no. Mr. Carter. Mr. Carter votes no. Mr. Pallone.
Votes aye.
Mr. Pallone votes aye. Mr. Rush. Ms. Eshoo. Ms. Eshoo votes aye. Mr. Engel. Mr. Engel votes aye. Mr. Green. Mr. Green votes aye. Ms. DeGette. Mr. Doyle. Mr. Doyle votes aye. Ms. Schakowsky. Mr. Butterfield. Mr. Butterfield votes aye. Ms. Matsui. Ms. Matsui votes aye. Ms. Castor. Ms. Castor votes aye. Mr. Sarbanes. Mr. Sarbanes votes aye. Mr. McNerney. Mr. McNerney votes aye. Mr. Welch. Mr. Welch votes aye. Mr. Lujan. Mr. Lujan votes aye. Mr. Tonko. Mr. Tonko votes aye. Ms. Clark. Ms. Clark votes aye. Mr. Loebsack. Mr. Loebsack votes aye. Mr. Schrader. Mr. Schrader votes aye. Mr. Kennedy. Mr. Cardenas. Mr. Cardenas votes aye. Mr. Ruiz. Mr. Ruiz votes aye. Mr. Peters. Mr. Peters votes aye. Ms. Dingle. Ms. Dingle votes aye. Chairman Walden.
Walden votes no.
Chairman Walden votes no. Mr. Kennedy? Mr. Kennedy votes aye.
Are there other members wishing to be recorded? Are there any other members wishing to be recorded? If not, the clerk will report the roll.
Mr. Chairman, on that vote, there are 21 ayes and 29 noes.
21 ayes, 29 noes. The amendment is not adopted. For what purpose does the gentleman from New Mexico seek recognition?
Mr. Chairman, I have an amendment at the desk.
Clerk will report the amendment.
Amendment to the draft oversight plan offered by Mr. Lujan.
The chair recognizes the gentleman from New Mexico to discuss his amendment.
Thank you, Mr. Chairman. Recently, the Department of Energy released a report regarding the state of our national laboratories. This report made clear that the national security labs, including Los Alamos and Sandia National Laboratories in New Mexico, are national scientific treasures. While the labs are tasked with ensuring the security of our nation's nuclear stockpile, they also have much broader economic impact. For example, programs such as the New Mexico Small Business Assistance Program provides needed technical assistance to small businesses in the region. The labs have led to startups such as Ubiquity, a Lanel spinoff that was recognized as a top growth company in New Mexico. I can honestly say that some of Lanel's contributions are truly out of this world, such as the ChemCam device, which Lanel developed for NASA's Mars rover program. These and many other successes at the national labs in New Mexico and across the country have bettered the lives of Americans. And that's why I introduced an amendment to the fiscal year 2013 National Defense Authorization Act to study the governance structure of the National Nuclear Safety or Security Administration, and continue to be committed to working with my colleagues on this committee and the administration to strengthen the long-term health of these critical institutions. The 2013 NDAA established the Congressional Advisory Panel on the Governance of the Nuclear Security Enterprise and tasked the panel to offer recommendations with respect to the most appropriate governance structure, mission, and management of the nuclear security enterprise, also known as the Augustin Mies panel. This Congressional Advisory Panel released an interim report in April of 2014 and a final report with recommendations in 2014. The advisory panel concluded that the, I quote, NNSA governance reform, at least as it has been implemented, has failed to provide the effective mission-focused enterprise that Congress intended. It also concluded that the relationships among NNSA, the Secretary of Energy, and the DOE headquarters are not properly aligned with mission needs today and are therefore in need of major reform. I believe that many of the recommendations made to Congress in the Augustine Mies report would strengthen the ability of DOE and NNSA to execute their critical missions, and that this report should receive greater scrutiny and attention from this committee. Though Secretary Moniz worked to address the issues raised by the Augustine Mies report, there is still much work to do. That's why I'm offering this amendment to the Oversight Plan, calling for the continued examination of the report's findings and recommendation and DOE's efforts to address these issues. While I appreciate the Subcommittee on Oversight and Investigations that they held a hearing to examine this report in February of 2015, one hearing on this subject is not enough. The mission of the NNSA and DOE is part of this committee's jurisdiction, and the findings made by the panel are particularly sobering given the mission of these two agencies. The National Nuclear Security Mission is too important for us to ignore these problems, and the work of the Augustine Mies panel provides the committee with a clear roadmap for meaningful reform. It should be clear to all of us, including Secretary of Energy nominee Rick Perry, that the department's role as safeguarding and maintaining our nation's nuclear deterrent must be a priority, especially if President Trump is truly considering substantive changes to the structure and mission scope of the National Security Laboratories. My amendment is intended to both recognize the importance of the expert recommendations of this committee contained in the Augustine Mies report and to ensure that together we begin the work of fixing the governance problems identified by the panel. I urge adoption, and I yield back the balance of my time.
Gentleman yields back the balance of his time. Chair would recognize himself for 5 minutes. As the gentleman and friend from New Mexico mentioned, the Oversight Committee did do a hearing on this issue. We do believe that our oversight plan already accommodates this, but in the spirit of the DCCC and the NRCC chair and former chair getting along, besides that, we think this is a really important issue. We're willing to adopt this amendment by unanimous consent. Is there further discussion on this amendment? Seeing none, all those in favor will say aye. Aye. Those opposed, nay. The ayes have it. No. The ayes have it. Correct? Yes. Well, yeah, we're into the vote on this one. I'm sorry. The ayes have it, and the amendment is agreed to. Are there other members seeking recognition? Chair recognizes the gentlelady. Who do you want? I don't know who is next. I think we're supposed to recognize Ms. DeGette next.
Chairman,
For what purpose does she seek recognition?
I have an amendment at the desk.
Clerk will report the DeGette amendment.
Amendment to the draft oversight plan offered by Ms. DeGette.
Without objection, further reading the amendment dispensed with. Chair recognizes gentlelady from Colorado, Ms. DeGette.
Thank you very much, Mr. Chairman. Mr. Chairman, recent weeks have been dominated by the discussion of Russia's attempts to influence the U.S. election. In October of 2016, the Department of Homeland Security and the Office of the Director of National Intelligence issued a joint statement that said, and I quote, "The U.S. intelligence community is confident that the Russian government directed the recent compromises of emails from U.S. persons and institutions, including from U.S. political organizations." The statement goes on to say that some of the disclosures of hacked emails were, quote, "consistent with the methods and motivations of Russian-directed efforts. These thefts and disclosures are intended to interfere with the U.S. election process. Such activity is not new to Moscow. The Russians have used similar tactics and techniques across Europe and Eurasia, for example, to influence public opinion there," end quote. The statement from DHS and the ODNI also says, quote, "We believe that based on the scope and sensitivity of these efforts, that only Russia's senior-most officials could have authorized these activities." Mr. Chairman, as you know, additional evidence has been made available to the public through a January 6, 2017 report released by the ODNI. Quoting from it, it said, quote, "We assess Russian President Vladimir Putin ordered an influence campaign in 2016 aimed at the U.S. presidential election. Russia's goals were to undermine public faith in the U.S. democratic process, denigrate Secretary Clinton, and harm her electability and potential presidency. We further assess Putin and the Russian government developed a clear preference for President-elect Trump. We have high confidence in these judgments," end quote. Mr. Chairman, the proposed oversight plan for the 115th Congress says that we will explore current cybersecurity threats and strategies to address those threats. Although I think this language provides the committee with latitude to examine a host of cyber-related activities, I do believe that we should closely examine which systems under this committee's jurisdiction may be vulnerable to the kinds of activities that were described by both the October 16th statement and more recently their January 17, 2017 report. We should specifically seek to understand whether those systems remain vulnerable, and if so, explore ways to better defend against and prevent further attacks. One agency that's in the committee's jurisdiction is the Federal Communications Commission. The FCC has the ability to take action to secure the nation's networks and assist Congress in making those networks resilient. And Mr. Chairman, I'm not making this amendment because of one party or the other. I'm really worried about this, and I think everybody on this committee is worried about it, whether you're a Democrat or Republican, and this is why I think it's really important that we focus in on this in our oversight and investigations efforts. With that, I've got a couple minutes. I'd like to yield to Mr. McNerney.
Thank you. Mr. Chairman, our enemies are using every method at their disposal to attack the United States. We need to make sure that we use all the tools at our disposal to defend our networks and protect our citizens. The FCC is the expert agency tasked with overseeing these networks. This is not a time for turf wars between agencies. They should all be doing what they can, and that includes the Department of Homeland Security, the National Telecommunications and Information Administration, the Department of Defense, and the Federal Trade Commission. As a committee, we need to make sure that the FCC is fully empowered and engaged in studying the problem and doing everything it can to prevent these attacks. Otherwise, I feel we're leaving our constituents unnecessarily vulnerable. This amendment will help ensure that the Energy and Commerce Committee focuses on protecting our networks and citizens from cyber threats this Congress. I urge all members to support Ms. DeGette's amendment. With that, I yield back.
Gentleman yields
Mr.
back.
Chairman, I yield back.
I'm sorry, the gentlelady yields back. Gentleman yields back. Are there other members seeking recognition? Chair recognizes the gentlelady from Tennessee, the new subcommittee chairman, the Communication Technology Subcommittee, Ms. Blackburn.
Thank you, Mr. Chairman. I think that everyone knows that cybersecurity has been a priority for this committee. As a simple fact, just look at the number of agencies that fall under our jurisdiction and our oversight jurisdiction because they're connected to the internet. And we plan to work to exercise and expand our presence in the cybersecurity debate throughout the 115th Congress. And while I appreciate the gentlelady from Colorado referencing the FCC doesn't represent the sum total of our jurisdiction over these important issues. And pointing to the FCC alone is looking at this issue through far too narrow a lens. And we do have a broad jurisdiction, and we are going to take a broad view. As we review the cybersecurity issues, Mr. Lance of New Jersey is going to be very involved in this issue on our subcommittee's behalf. I think it's important to realize, too, that cybersecurity cuts across all industries. There is no silver bullet, and there is absolutely no single agency that can create perfect cybersecurity. This amendment is not the approach to ensuring the protection of Americans online, and I would encourage my colleagues to vote no.
Will the gentlelady yield?
I will yield.
Thank you. I just want to clarify. I don't want there to be a misunderstanding that this amendment just relates to the FCC, because in the oversight plan in general, we talk about all of the agencies. So this amendment would talk about the FCC, but this would apply to every agency, not just the FCC. I yield back.
And reclaiming my time, we are going to take a broad view of this, and we're going to be able to move forward through an orderly process. And with that, I again urge a no vote.
Gentlelady yields back balance for time. She does. There's further discussion on the amendment. There's no further discussion on the amendment. The question now arises. Those in favor will vote aye. Those nay, the clerk will call the roll.
Mr. Barton. Mr. Barton votes no. Mr. Upton. Mr. Upton votes no. Mr. Shimkus. Mr. Shimkus votes no. Mr. Murphy. Mr. Murphy votes no. Mr. Burgess. Mr. Burgess votes no. Mrs. Blackburn. Mrs. Blackburn votes no. Mr. Scalise. Mr. Latta. Mr. Latta votes no. Mrs. McMorris-Rogers. Mr. Harper. Mr. Harper votes no. Mr. Lance. Mr. Lance votes no. Mr. Guthrie. Mr. Guthrie votes no. Mr. Olson. Mr. Olson votes no. Mr. McKinley. Mr. McKinley votes no. Mr. Kinzinger. Mr. Kinzinger votes no. Mr. Griffith. Mr. Griffith votes no. Mr. Bilirakis. Mr. Bilirakis votes no. Mr. Johnson. Mr. Johnson votes no. Mr. Long. Mr. Long votes no. Mr. Bouchon. Mr. Bouchon votes no. Mr. Flores. Mr. Flores votes no. Mrs. Brooks. Mrs. Brooks votes no. Mr. Mullen. Mr. Mullen votes no. Mr. Hudson. Mr. Hudson votes no. Mr. Collins. Mr. Kramer. Mr. Kramer votes no. Mr. Wahlberg. Mr. Wahlberg votes no. Mrs. Walters. Mr. Costello.
No.
Mr. Costello votes no. Mr. Carter. Mr. Carter votes no. Mr. Pallone. Mr. Pallone votes aye. Mr. Rush. Ms. Eshoo. Ms. Eshoo votes aye. Mr. Engel. Mr. Green. Mr. Green votes aye. Ms. DeGette. Ms. DeGette votes aye. Mr. Doyle. Mr. Doyle votes aye. Ms. Schakowsky. Ms. Schakowsky votes aye. Mr. Butterfield. Mr. Butterfield votes aye. Ms. Matsui. Ms. Matsui votes aye. Ms. Castor. Ms. Castor votes aye. Mr. Sarbanes. Mr. Sarbanes votes aye. Mr. McNerney. Mr. McNerney votes aye. Mr. Welch. Mr. Welch votes aye. Mr. Lujan. Mr. Lujan votes aye. Mr. Tonko. Mr. Tonko votes aye. Ms. Clark. Ms. Clark votes aye. Mr. Loebsack. Mr. Loebsack votes aye. Mr. Schrader. Mr. Schrader votes aye. Mr. Kennedy. Mr. Kennedy votes aye. Mr. Cardenas. Mr. Cardenas votes aye. Mr. Ruiz. Mr. Ruiz votes aye. Mr. Peters. Ms. Dingle. Ms. Dingle votes aye. Chairman Walden.
Walden votes no.
Chairman Walden votes no.
Are there other members wishing to be recorded? Gentlelady from California.
Ms. Walters votes no.
Are there any other members wishing to be recorded? Gentlelady from Washington State.
Mrs. McMorris-Rogers votes no.
Other members? If not, the clerk will report the tally.
Mr. Chairman, on that vote, there were 21 ayes and 29 noes.
21 ayes, 29 noes. The amendment is not approved. Are there other members seeking recognition? Gentlelady from California, Ms.
Thank
Eshoo.
you, Mr. Chairman. I have an amendment at the desk.
Clerk will report the amendment. Which one is it, Ms.
This
Eshoo?
is on our oversight of on medical devices. It's 29.
It's the Medical Device Safety Amendment. We believe it to be I don't believe we have numbers on them, right?
Well, they were numbered on the list of,
I think that's an
Yeah.
internal document that you
Okay.
have that we don't have.
was it secret?
I don't,
Oh,
I'd have
okay.
to ask your
That's
ranking.
why I used 29.
Yeah, that was not shared with us, so that's
right.
why we have to do this.
Amendment to the draft oversight plan offered by Ms. Eshoo.
With unanimous consent, the clerk will dispense with the further reading of the amendment, and the chair recognizes gentlelady from California.
I
regarding her
understand.
amendment.
Thank you, Mr. Chairman. I understand that every member that's speaking is drawing less and less attention to what they're saying. So let me just say this quickly. I think this is something that that we can all come together around. We know that medical devices have brought about extraordinary breakthroughs in the field of healthcare. And we acknowledge that the FDA is the federal agency responsible for regulating these devices. The reason I'm offering the amendment is that the oversight plan to establish our committee's jurisdiction does not include medical devices in terms of in the oversight plan, and I think that it should be. That's as simple as I can make it. And maybe it was just overlooked, but I think that it's very important. And years ago, I did oversight on medical devices, and Mr. Barton and I, at that time, authored major legislation based on our oversight and reformed the entire medical device industry. So I would just ask everybody to support this. I think it's important to have it be part of our plan, and I yield back.
Gentlelady yields back, and I would now recognize the gentleman from Texas, the new chairman of the Health Subcommittee, Mr. Burgess.
Mr. Chairman, I would just briefly say I believe the oversight plan already covers this, but I think it would be in the interest of bipartisanship. Perhaps we'll accept the amendment, or that would be my recommendation.
And gentleman yields back the balance of his time. Further discussion on the SU amendment, medical devices? Seeing no further discussion, no one seeking recognition, the question now comes on adoption of the amendment. All those in favor will say aye. Aye. Those opposed, nay. The ayes appear to have it, the ayes have it, and the amendment is adopted. Is there anyone seeking recognition? Gentleman from Maryland, Mr. Sarbanes, for what purpose do you seek recognition?
Mr. Chairman, I have an amendment at the desk.
Which amendment is this?
This is an amendment relating to oversight of an investigation of efforts by the Trump administration to generate profits.
Okay. Clerk will report the amendment.
Amendment to the draft oversight plan offered by Mr. Sarbanes.
With unanimous consent, we'll suspend with further reading of the amendment. And the chair now recognizes the gentleman from Maryland, Mr. Sarbanes, for 5 minutes to discuss his amendment.
Thank you, Mr. Chairman. This amendment would amend the committee's oversight plan to include investigation of any efforts by the Trump administration to generate profits for the Trump organization or businesses that supported the Trump campaign through regulatory decisions or selective enforcement. This is a simple and appropriate assertion of Congress's constitutional duty of executive branch oversight, and I think an appropriate exercise of this committee's oversight. As has been widely reported, and I make this point because I don't want my colleagues to think that this is a sort of gratuitous amendment that's being offered. We all know that President Trump is coming into office with a far-flung business enterprise like nothing we've ever seen in our history. It's an unprecedented array of potential conflicts of interest that arise when you look at that web of businesses both at home and abroad. So this is, in a sense, this presidency is a case of first impression in terms of the kind of oversight and standards that we need to apply to make sure that the public interest is being put forward without prejudging, frankly, whether the president is in a position of divided loyalties or not. It's just that we need to be attendant to that. The fact that the president has chosen to retain full ownership of his business, though, does create a problem. In other words, the president could address many of the issues I'm concerned about, and I think our colleagues are concerned about, if he fully divested of his interest in his business. But having not done that, the potential for conflicts to arise and the need for this committee to bring attention to them, I think, is significant. And also the potential for scandal, which we don't want to see. I mean, in a sense, the oversight I'm asking for here is a way to protect the president from himself or to protect the presidency from these potential conflicts and lapses. And the American people are already prepared for the potential for scandal if you look at some of the polling. So I think we need to take steps to try to prevent that from happening. The conflicts are not unique to the president. As many of us know, a lot of the nominees that he's put forward come with their own conflicts of interest that need attention. The president campaigned on a pledge to, quote, drain the swamp. But if you look at some of these appointees, he seems to be bringing more conflicts into the situation rather than distancing himself from them Examples include Scott Pruitt, his nominee to head the EPA, who's got a very long-standing and close relationship to big oil and gas, and has opposed environmental regulations that would make sense for the country. Rex Tillerson, his nominee to lead the State Department, longtime CEO, as we know, of Exxon Mobil, and there needs to be concern about whether decisions made there are ones that are being made in the public interest or for the benefit of energy industry players. Tom Price, our colleague, and there's some concerns there about potential conflicts of interest. So I offer this amendment because I think that the committee has a responsibility to ensure that the Trump administration, when it's carrying out its actions and making important decisions, is doing so in the public interest and not based on conflict of interest. Our committee is well placed to insist upon that, and that's why we propose this particular amendment. The public is asking this president to look out for them, not look out for himself. I think we can help in that endeavor and make sure that this president, when he's making important decisions, does not do so in a way that creates divided loyalties. We shouldn't have to wonder whether the important decisions carried out are ones that are being made for the benefit of the public or being made for the benefit of the president and his business interests. I think amending the oversight plan to include this kind of oversight can help with that. And I yield back, encourage my colleagues to support this amendment to the oversight plan.
Gentleman yields back the balance of his time. Chair recognizes the gentleman from Pennsylvania, the chairman of the Oversight and Investigation Subcommittee, the very capable Mr. Murphy.
Thank you, Mr. Chairman. I want to comment on this because this is an issue that goes back really to the Magna Carta and parliamentary law and our early Constitution, where a person should be afforded due process. And that is, you don't charge someone and you don't even start an investigation until someone has actually done something that's requires an investigation. Further, the preamble of this committee's authorization and oversight plan outlines some general principles that committee oversight activity will follow. We will, for example, conduct thorough oversight, reach conclusions based on an objective review of the facts, we will treat witnesses fairly, and we will request information in a responsible manner that is calculated to be helpful to the committee in its oversight responsibilities. Now, this committee, the Subcommittee of Oversight and Investigation, focuses on 1, waste, fraud, and abuse, and 2, ensuring laws are adequate to protect the public interest or are being implemented in a manner that protects the public interest. This amendment offered today is a dramatic departure from the existing preamble because instead of describing committee best practices, it would make the administration the subject of immediate committee investigation without any facts to support it. In addition, the amendment would establish a permanent presumption that the administration is at all times acting in bad faith and to generate profits for businesses with connection to the president. Under current law, all high-level federal officials are required to file a public financial disclosure statement, members here included, including the president. The statements are thorough and include disclosures of private income, gifts received, assets and income-producing property of over $1,000 in value, liabilities exceeding $10,000, financial transactions exceeding $1,000 in income-producing property and securities, positions held in outside businesses and organizations, agreements for future employment or leaves of absence with private entities, continuing payments from or participation in benefit plans of former employees, and the cash value of the interest in any blind trust. If members are interested in the President's finances, I encourage them to take advantage of existing law and review those forms. We do not need to make a partisan game of our oversight plan and begin a hunt before this all begins. I yield back.
Gentleman yields back.
Will the gentleman yield just for?
Gentlemen, do you want to yield? Yeah, he yields.
Yeah, thank you. Thank the gentleman for yielding. I take your point about the current language of the oversight and the preamble and the desire to protect the public interest, and I think obviously the amendment I'm proposing is consistent with that. You're right, it does seek to establish a little bit of a presumption in the way the committee is going to do its oversight, but I don't think it's a presumption of bad faith on the part of the administration. I think it's presumption of potential conflict of interest, which is coming from the fact that the president has not adequately dealt with his interests in terms of divesting of his business interests. So we're placed in a position where on day one of his presidency, these conflicts can present themselves, and I think that warrants the extra level of oversight that this and specificity that this amendment would bring to
reclaiming
the plan.
my time, then, if the gentleman would go back. The concern still here is operating an investigation on the basis of a presumption. I don't think that's a good basis for how the subcommittee or the committee should act to do investigations on the basis of presumptions. The facts will speak for themselves if ones emerge that are under the jurisdiction of this committee, and at that time we will move forward fairly and judiciously to do that. But I ask at this time that members oppose this amendment because I think that undermines some of the basic constitutional rights that we should operate under. I yield back.
Gentlemen, yield back. Is there further discussion on the Sarbanes amendment? See none. The vote now occurs on the Sarbanes amendment. Those in favor say aye. Oh, wait a minute. Okay, sorry. There's a request for a roll call vote. So, clerk will call the roll. Those in favor vote aye. Those opposed, nay. And the clerk will call the roll.
Mr. Barton. Mr. Barton votes no. Mr. Upton. Mr. Upton votes no. Mr. Shimkus. Mr. Shimkus votes no. Mr. Murphy. Mr. Murphy votes no. Mr. Burgess. Mr. Burgess votes no. Mrs. Blackburn. Mrs. Blackburn votes no. Mr. Scalise. Mr. Latta. Mr. Latta votes no. Mrs. McMorris-Rogers. Mr. Harper. Mr. Harper votes no. Mr. Lance. Mr. Lance votes no. Mr. Guthrie. Mr. Guthrie votes no. Mr. Olson. Mr. Olson votes no. Mr. McKinley. Mr. McKinley votes no. Mr. Kinzinger. Mr. Kinzinger votes no. Mr. Griffith. Mr. Griffith votes no. Mr. Bilirakis. Mr. Bilirakis votes no. Mr. Johnson. Mr. Johnson votes no. Mr. Long. Mr. Long votes no. Mr. Bouchon. Mr. Bouchon votes no. Mr. Flores. Mr. Flores votes no. Mrs. Brooks. Mrs. Brooks votes no. Mr. Mullen. Mr. Mullen votes no. Mr. Hudson. Mr. Hudson votes no. Mr. Collins. Mr. Collins votes no. Mr. Kramer. Mr. Kramer votes no. Mr. Wahlberg. Mr. Wahlberg votes no. Mrs. Walters. Mrs. Walters votes no. Mr. Costello.
No.
Mr. Costello votes no. Mr. Carter.
Yeah,
Mr. Carter votes no.
With the leader.
Mr. Pallone.
Votes aye.
Mr. Pallone votes aye. Mr. Rush. Ms. Eshoo. Ms. Eshoo votes aye. Mr. Engel. Mr. Green. Mr. Green votes aye. Ms. DeGette. Ms. DeGette votes aye. Mr. Doyle. Mr. Doyle votes aye. Ms. Schakowsky. Ms. Schakowsky votes aye. Mr. Butterfield. Mr. Butterfield votes aye. Ms. Matsui. Ms. Matsui votes aye. Ms. Castor. Ms. Castor votes aye. Mr. Sarbanes. Mr. Sarbanes votes aye. Mr. McNerney. Mr. McNerney votes aye. Mr. Welch. Mr. Welch votes aye. Mr. Lujan. Mr. Lujan votes aye. Mr. Tonko. Mr. Tonko votes aye. Ms. Clark. Ms. Clark votes aye. Mr. Loebsack. Mr. Loebsack votes aye. Mr. Schrader. Mr. Schrader votes aye. Mr. Kennedy. Mr. Kennedy votes aye. Mr. Cardenas. Mr. Cardenas votes aye. Mr. Ruiz. Mr. Ruiz votes aye. Mr. Peters. Mr. Peters votes aye. Ms. Dingle. Ms. Dingle votes aye. Chairman Walden.
Nope.
Chairman Walden votes no.
Are there other members wishing to be recorded? The gentlelady from Washington State.
Mrs. McMorris-Rogers votes no.
Are there any other members wishing to be recorded? If not, the clerk will report the tally.
Mr. Chairman, on that vote, there were 22 ayes and 30 noes.
22 ayes and 30 noes. The amendment is not agreed to. Are there further amendments?
Mr. Chair, I have an amendment at the desk.
The clerk will report the amendment.
I believe it's Amendment 9.
We do not appear to have your amendment at the desk. We have it. Can you describe what your
Number 9, I believe.
Do we find the amendment? Okay. Yeah, it's just helpful if you can describe them. We don't have the cheat sheet by number, so.
Amendment to the draft oversight plan offered by Mr. Tonko.
Unanimous consent. Further reading of the amendment is dispensed with. The chair recognizes the gentleman, Mr. Tonko, for 5 minutes.
Thank you, Mr. Chair. This amendment would put additional focus on our nation's drinking water system's needs, the potential to create jobs, the dangers of unregulated contaminants, and the ongoing crisis in Flint. While the proposed oversight plan does mention drinking water infrastructure and regulation, I would suggest that it does not go nearly far enough. There is much more in this committee's jurisdiction that we must examine. The proposed oversight plan includes the need to improve efficiencies and leverage investments from the Drinking Water State Revolving Fund. I'm sure we could all support this, but I was disappointed that the plan is silent on the need for more investment and to reauthorize the Drinking Water SRF, which was created and last authorized in 1996. Now, over 2 decades later, we are reaping the consequences of our negligence. Water systems are struggling with aging infrastructure and widespread unregulated and underregulated contaminants. Communities are spending far too much money on emergency repairs and not enough on planned maintenance. Improving efficiency can only get us so far. At some point, our federal government will need to send more financial support to state and local governments. Unfortunately, this is at odds with the new administration's targeting of more than $500 million worth in grants to states provided by EPA. Also, I want to mention the reports that emerged last night regarding a freeze on EPA grants and contracts. While we still do not know the length or scope of this freeze, I find it deeply troubling that EPA provides critical public health funding on water quality and infrastructure that might have those programs threatened. I am all for oversight of these programs, but freezing grants is a dangerous decision that goes against the will of Congress when we appropriated the agency these funds. This includes funds that were recently approved through the SRF to provide relief to Flint. I hope every member of this committee will oppose this decision and call for an immediate end to this policy. EPA has estimated that over the next 20 years, water systems will require some $384 billion to keep their drinking water systems running. This need has grown every time that EPA has estimated it. Last year's Water Infrastructure Improvements for the Nation Act failed to include strong Buy America language. With greater investments and requirements for American parts, I have no doubt that we will create many jobs in every district. Additionally, the proposed plan calls for oversight of EPA's regulatory actions. I would argue that we should be far more concerned by the agency's inaction. EPA has a well-documented inability to set national primary drinking water standards since the passage of the Safe Drinking Water Act amendments in 1996. The 1996 amendments significantly changed the EPA's process for regulating contaminants. No new standards have been set since then, despite the fact that a number of harmful contaminants have been showing up in water systems across our country. EPA has acknowledged the problems of many of these dangerous, unregulated contaminants, such as PFOA, but has been unable to set a new standard. Our constituents should not have to turn on the tap in fear that it may harm their families. We should examine whether EPA has the resources and authorities necessary to make sure we are all continuing to guarantee safe drinking water to all Americans. I would also mention that the previous administration led us to believe that we could expect a revision of the lead and copper rule in 2017. I hope that President Trump's administration finalizes this rule and this committee prioritizes the health of the millions of Americans that live with systems that violated this rule last year. Finally, the proposed plan makes no mention to Flint, Michigan, or any of the other communities that are struggling with significant water quality issues. Sadly, residents in Flint are still without safe drinking water. This, in fact, is shameful. Last year's Water Infrastructure Improvements for the Nation Act provided some relief to the city of Flint, as well as new grant programs to replace lead service lines and support disadvantaged and small communities. This is a start, although this new grant freeze from the administration may undermine the efforts of Congress to provide for some hard bipartisan work that will be successful. This committee must play a role in successfully implementing these new programs. I know if our committee takes a leadership role on these issues from the outset of this Congress, we can accomplish even more. I urge support of this amendment to create a more robust oversight plan for our nation's drinking water systems. With that, I yield back.
Chair recognizes the gentleman from Illinois.
Thank you, Mr. Chairman. And I have great respect for my ranking member of the subcommittee, and I look forward to working with him on some of these issues. But I would ask my colleagues to not support this amendment. The purpose of this meeting is to vote today on the oversight plan representing many committee priorities, not litigate issues or presume the answers. The committee has included in this document's plan to consider the broad impact of the state revolving loan funds established in Section 1452 of the Safe Drinking Water Act, which may include state drinking water programs and national need, as opposed to state-by-state needs, by the Audit Committee, federal cross-cutting requirements on resolving fund dollars, including Buy American Iron and Steel, examining the economic impact of every federal dollar used in infrastructure development, or funding of the Flint lead pipe response under WRDA, pursuant to Section 1452 of the Safe Drinking Water Act. The committee's oversight plan already makes accommodations for EPA activities for addressing emerging contaminants. This would include, but not be limited to, the very difficult word of perfluorinated compounds or algal toxins. And so with that, I'd ask my colleagues to not support the amendment. I look forward to working with my colleague from New York, and I yield back my time.
The gentleman yields back the balance of his time. Are there other members seeking recognition? Seeing none. Oh, I'm sorry. He was standing up. Ms. Dingle is recognized.
Move to strike the last word.
The gentlelady is recognized.
I'll be quick because I know votes have been called, but I rise to I'm supporting this amendment. Drinking water is such a critical issue. It should never be partisan. We've had another scare in my downrivers last week with dirty colored water. They didn't make transparent the tests. We need to work together. And now we're telling the people of Flint that they've got to wait again. I urge all of us to work together to tell the American people we're going to keep their water safe. Thank you.
Gentlelady yields back. Does the gentleman seek a recorded vote? Okay, those in favor of the gentleman's amendment will vote aye. Those opposed, nay. The noes have it. The amendment is not adopted. Now, for the committee. The ranking member and I have discussed the future for this evening. Members of the minority have several amendments left to be considered. We will reconvene because of some other conflicts at 5:45. And during that period, Mr. Pallone, I'll yield to you.
The problem we have is that there are many members that have told me that they have to take flights tonight. So we're going to reconvene at 5:45. But whatever amendments we have on our side, we're going to try to condense into a half-hour period so we can be done by 6:15. So we'll talk between now and 5:45 about what amendments and how much time we would have on those. I know some people may not be able to come back, but hopefully can come back at least for that half hour between 5:45 and 6:15.
So our intent is to wrap up by 6:15, adopt the final package here, and then adjourn. With that, the committee stands in recess. We will call the full Energy and Commerce Committee back to order. When we left, we agreed we would come back and start at 5:45, which we have basically done. We also, ranking member and I have agreed we will end at 6:15. Both sides have agreed to this. We will end at 6:15 and then have a final vote on the oversight plan. We will also agree, we have, to 1 minute on per member to debate these amendments. That was a request of the ranking member, which I agreed to, that we would limit our debate to 1 minute apiece on these amendments. So with that,
Mr. Chairman, if
I
I
would
could
recognize my friend from New Jersey, Mr. Pallone.
I mean, I know we still have members coming in, but I'm also asking, we're doing some of the Democratic amendments en bloc, and I'm basically asking that only the members who are sponsoring amendment, including the en bloc parts of the amendment, would speak, because if everybody speaks, we're not going to have time. So 1 minute, and try to only have the sponsors of the amendment, including the en blocs, to speak. Thank you, Mr. Chairman.
Mr. Welch. Mr. Welch.
Mr. Yeah, I'm ready.
Okay. Chair recognizes the gentleman from Vermont, Mr. Welch.
Thank you, Mr. Chairman. I ask unanimous consent to call up amendment number 28 on energy efficiency, and I understand from conversations with Mr. Upton that if I'm allowed to amend a few words.
Yeah, well, let's have the clerk report the amendment.
Thank you.
Amendment to the draft oversight plan offered by Mr. Welch.
I don't think your microphone was on.
Amendment to the draft oversight plan offered by Mr. Welch.
Okay. With unanimous consent, we'll dispense with further reading of the amendment. Mr. Welch, do you want to describe your amendment as amended?
My amendment would, on the intro, after page 4, comma, take out, strike the section entitled, and in the title, it would delete the word promotion, and then the text of the amendment would be the same. And I'd ask unanimous consent to be permitted to make those amendments to my amendment.
Without objection, the amendment would be amended to say on page 4 at the end of the section, energy efficiency mandates, insert the following, energy efficiency, and then the language.
That's correct.
Without objection, so ordered.
If the gentleman will yield, knowing that we've
glad to yield.
We've looked at the language. We think that it's a good addition, and glad to accept it.
Well, let's have Mr. Welch speak to his amendment.
To the gentleman, the language that he wrote.
All right. Did you want to speak on it any further, Mr. Upton? If you want to.
I'll be glad to strike the last word for a minute.
1 minute.
I just, we've got a lot of members on both sides of the aisle that care deeply about energy efficiencies. We passed a bill on the House floor last night unanimously that the Senate didn't take up. And I think this is a good change and one that we can accept. And thank the gentleman for changing the language so that it's acceptable on this side. Thank you.
Gentleman yields back. Any other member seeking recognition on the Welch amendment? Seeing none. Seeing none, the question now arises on approving the Welch amendment. All those in favor will say aye. Aye. Those opposed, nay. The ayes have it, and the amendment is adopted.
Mr. Chairman.
Gentleman from Texas, Mr. Green, for what purpose do you seek recognition?
Mr. Chairman, I ask unanimous consent to offer the Green, Cardenas, and Schrader and Loebsack amendments in block, amendments 13, 12, 15, and 17, respectively.
All right. Let's let the clerk get those amendments. And again, we don't have those amendment numbers unless they've been added during the break. Correct?
An en-bloc amendment offered by Mr. Green.
I ask unanimous consent that we dispense with further reading of the amendment, and I would recognize the gentleman from Texas, Mr. Green, to describe his amendment.
Okay. Thank you, Mr. Chairman. I'll explain by one sentence on each of these amendments. The Cardenas Amendment would add the examination of insurance rates for children and state outreach efforts to enroll insured children in the Oversight Plan. The Schrader Amendment would instruct this committee to examine the effect of the Affordable Care Coverage provisions on access to health care and the detrimental effect that repeal would have on its access. The amendment offered by Mr. Loebsack would add an examination of the effect of the Affordable Care Act on access to health care in rural areas, including the ACA's impact on rural hospitals and the detrimental effect that the repeal would have on this. And my amendment would direct the committee to examine the state economic impact of Medicaid expansion, the impact expansion has on access to coverage and care, and the detrimental effect that repeal would have on state budgets and patients who fall within the 100 and 133% of federal poverty level. Mr. Chairman, I think each of these amendments are some concern on how we're going to address the Affordable Care Act in this new Congress. I think the members on our side of the aisle are doing individual items, but what we would like to see is if we're going to deal with the Affordable Care Act, not to cherry pick different sections, is to look at the whole law and see if we can improve it and make it better. And that's what I think this amendment does. I can talk about the benefit of Medicaid. 1 in 7 seniors count on Medicaid for health care coverage. Medicaid's the primary source of long-term care for Americans. If Medicaid didn't exist, the vast majority of Medicaid's 74 million beneficiaries would be uninsured. But that's our concern, Mr. Chairman, that we have a comprehensive effort through the Health Subcommittee and our full committee on dealing with the Affordable Care Act. And I'd be glad to yield any amount.
Well, the gentleman's time's expired, remember, on 1 minute, and you ended up with 2. We'll now recognize the gentleman from Texas, Dr. Burgess, Chairman of the Health Subcommittee.
Thank you, Mr. Chairman. I don't know how to do this in 1 minute, but I do urge no vote for all 4 amendments. On the Green Amendment, the committee resources are best spent by working to sustain and strengthen Medicaid for the most vulnerable Medicaid patients. House Republicans have a better way to provide access, coverage, and medical services for low-income Americans in a more sustainable, affordable, cost-effective fashion. Mr. Cardenas's amendment is another attempt on the other side of the dais to distract from the harm that Obamacare has done to patients and families across the country. I oppose this amendment and support solutions-oriented bills, such as loosening the age rating band from 3 to 1 to 5 to 1 while giving states the option to narrow or widen this standard. The amendment offered by Mr. Schrader is, again, another attempt to distract from the harm that the Affordable Care Act has done to patients and families across the country. 21 states have seen average premium increases of 25% or more. Only 1 in 5 original 23 health insurance co-ops remain in business. Again, oppose the amendment. And finally, the amendment offered by Mr. Loebsack. Again, the reason we're even in the situation where Republicans are having to rescue Americans is because of how poorly constructed the Affordable Care Act was. If we were doing nothing, the law would collapse under its own weight beginning in 2018. I yield back and urge a no vote.
Gentleman yields back. Chair recognizes the gentleman from Iowa, Ms. Loebsack, for 1 minute.
Thank you, Mr. Chair. I'm offering this amendment to our oversight plan so that the committee can better understand how our health care policy decisions affect rural areas throughout the country. You can understand that, Mr. Chair. I think your district might be larger than all of Iowa, as you've reminded me in the past. Too often, we see folks in rural America lack access to quality medical services. With nearly 1 in 5 uninsured Americans living in rural America, it is imperative that we ensure that rural America is not left out moving forward regarding the health of our nation. And with only 10% of the doctors practicing in these areas, I'm glad that the ACA has provided new resources to increase the number of doctors and nurses in rural areas, such as new scholarships, loan repayment programs, and Medicare payment incentives to encourage providers to practice in rural communities. In short, the ACA has been good for rural America. My amendment will further study the effects of the ACA and on rural areas, and I urge my colleagues to support it, and I yield back.
Gentleman yields back his time. Chair recognizes gentleman from Michigan, Mr. Upton.
Well, thank you, Mr. Chairman. You know, one of the reasons that we're in this situation is that the numbers haven't looked so good for the Affordable Care Act. 21 states have seen their average premium increase of 25% or more. 7 states are over 50%. In 2016, 225 counties had just one insurer, and the next year, 2017, that almost quadrupled to 1,022 counties with just one insurer. 5 states have just one insurer offering coverage on the exchange, and only 5 of the original 25 health insurance co-ops remain in business. So this needs to be re-examined, and this amendment doesn't do it. So I would urge my colleagues to vote no, and I yield back the balance of my time.
Gentleman yields back the balance of his time. Chair recognizes Mr. Cardenas, California.
Thank you very much, Mr. Chairman. I'm going to try to remain calm and follow my notes after what I just heard, the accusations of what some of our amendments are attempting to do. My amendment would have the oversight within the subcommittee to monitor insurance coverage rates for our nation's children and further federal and state efforts to improve upon that coverage rate through outreach and enrollment efforts. We have made huge gains in coverage for our nation's children in recent years, gains that should not be lost. The Medicaid expansion in the Affordable Care Act has helped our country to realize the highest rates of insurance coverage for children. That brings it to 95.2% in 2015. That is something that America should be proud of. One of the most effective strategies for states to reach eligible but uninsured children is to put out the welcome mat for the whole family by extending Medicaid coverage to parents and other low-income adults. States choosing to expand Medicaid coverage to more low-income adults will not only reduce the number of uninsured children, but will also boost children and families' long-term economic security, and kids benefit when their parents are healthier.
Gentleman's time has expired.
I thought I had, shoot. Anyway, thank you very much. I yield back.
Thank you. Other members seeking recognition. Chair recognizes gentleman from Pennsylvania.
Just very quickly, Mr. Chairman, this is another attempt to distract from what we need to be doing with the Affordable Care Act. It's been very clear. We've repeatedly said we support maintaining the rule that allows people under age 26 to stay on their parents' plan. We want to make coverage more affordable for younger patients. Right now, it's very costly, and that's why many of them do not choose to get health care. They may sign up for insurance, they just can't afford to get sick because the deductibles and copays are so high. Loosening the age rating bands are going to be a way to help make it more affordable. We will work on that. And I might add, too, in our ongoing investigations, oversight investigation, we've repeatedly worked in the past to try and get HHS to give us data on people who signed up, Medicaid, people who've lost their insurance, people who signed up. We never did get a lot of that, and we will continue to investigate to make sure we're doing the best. But I certainly say that everybody in this committee, I believe, supports continuing coverage for those under age 26, and I can't imagine we're going to change that now, and I yield back.
Gentleman's time's expired. Chair recognizes gentleman from New Jersey.
I know some members came later. We're operating under a 1-minute rule now, and we're asking only those who have sponsored the amendments to actually speak. and we're going to have a roll call on everything other than the things that are agreed on. So I'll leave it at that, Mr. Chairman.
Gentleman yields back.
Yes.
Gentleman yields back. Are there other members seeking recognition?
You're next.
Is there somebody else? Nobody else?
Mr. Schrader.
Oh, Representative.
Well, we didn't vote on this yet.
But on this package, you're seeking recognition? No.
On this package, yes, sir.
Yeah, okay. Chair recognizes gentleman from Oregon, Mr. Schrader.
Thank you very much, Mr. Chairman. I'd like to comment on my amendment. It's very simple. It simply asks us to look at the real facts, not the so-called alternative facts about what the ACA has done. More than 20 million people have gained coverage. 129 million Americans with pre-existing conditions are covered. Women cannot be charged more, denied coverage because of their gender. No lifetime, no annual limits on coverage. 9.4 million have purchased private insurance with the help of the premium tax credits. And in our state alone, the 16 CCOs cover the entire Medicaid population. It's an unqualified success. In exchange for dollars to set up those CCOs, Oregon agreed to keep medical inflation under 3.4%. Other states that didn't do that, they're 11+%, most difficult population to take care of. And we've done it without sacrificing quality. Hospital readmissions are down 30%. Diabetes complications down 30%. Primary care enrollment up 70%. Dental care for kids up 65%, and ER visits down 40%. My amendment will help us better understand the importance of these coverage provisions, and I ask my colleagues to support it today. Thank you, sir.
Gentleman, time expired. Are there other members seeking recognition? Mr. Butterfield.
Mr. Chairman, I want to speak in support of Mr. Lobsak's amendment. I think it's very timely. Repeal will be devastating to rural areas, not just in the Midwest, but in the rural South as well. The rural hospitals in my district are operating on the margin already. Repeal would be devastating. I yield the balance of my time to Mr. Green.
Thank my colleague for yielding. And, Mr. Chairman, I'll close. These are just 4 amendments that we know we're concerned about. And I know there's no law that's ever been passed by this Congress or a state legislature that doesn't need to go back and revisit it. I just want to make sure, and I think our side wants to make sure that we look at the total of the legislation and that we don't take away some of the things that people have been beneficial for. Even the president talked about some of the good things in it. So that's all we want to do is say these are 4 things, but there's probably dozens of more other ones that we could do. But be glad to look forward on a regular order, looking at what we can do to improve the Affordable Care Act and fix it. And I yield back.
Gentleman yields back balance of his time. Other members seeking recognition? Seeing none. There's a request for a roll call vote. So all those in favor will vote aye. Those opposed, nay. And the clerk will call the roll.
Mr. Barton. Mr. Barton votes no. Mr. Upton. Mr. Upton votes no. Mr. Shimkus. Mr. Shimkus votes no. Mr. Murphy. Mr. Murphy votes no. Mr. Burgess. Mr. Burgess votes no. Mrs. Blackburn. Mrs. Blackburn votes no. Mr. Scalise. Mr. Latta. Mr. Latta votes no. Mrs. McMorris-Rogers. Mrs. McMorris-Rogers votes no. Mr. Harper. Mr. Harper votes no. Mr. Lance. Mr. Lance votes no. Mr. Guthrie. Mr. Guthrie votes no. Mr. Olson. Mr. McKinley. Mr. McKinley votes no. Mr. Kinzinger. Mr. Kinzinger votes no. Mr. Griffith. Mr. Griffith votes no. Mr. Bilirakis. Mr. Bilirakis votes no. Mr. Johnson. Mr. Johnson votes no. Mr. Long. Mr. Long votes no. Mr. Bouchon. Mr. Bouchon votes no. Mr. Flores. Mr. Flores votes no. Ms. Brooks. Ms. Brooks votes no. Mr. Mullen. Mr. Mullen votes no. Mr. Hudson. Mr. Hudson votes no. Mr. Collins. Mr. Collins votes no. Mr. Kramer. Mr. Kramer votes no. Mr. Wahlberg. Mr. Wahlberg votes no. Mrs. Walters. Mrs. Walters votes no. Mr. Costello.
No.
Mr. Costello votes no. Mr. Carter. Mr. Carter votes no. Mr. Pallone.
Votes aye.
Mr. Pallone votes aye. Mr. Rush. Ms. Eshoo. Mr. Engel. Mr. Engel votes aye. Ms. Green. Mr. Green. Mr. Green votes aye. Ms. DeGette. Ms. DeGette votes aye. Mr. Doyle. Ms. Schakowsky. Ms. Schakowsky votes aye. Mr. Butterfield. Mr. Butterfield votes aye. Ms. Matsui. Ms. Matsui votes aye. Ms. Castor. Mr. Sarbanes. Mr. Sarbanes votes aye. Mr. McNerney. Mr. McNerney votes aye. Mr. Welch. Mr. Welch votes aye. Mr. Lujan. Mr. Lujan votes aye. Mr. Tonko. Mr. Tonko votes aye. Ms. Clark. Ms. Clark votes aye. Mr. Loebsack. Mr. Loebsack votes aye. Mr. Schrader. Mr. Schrader votes aye. Mr. Kennedy. Mr. Kennedy votes aye. Mr. Cardenas. Mr. Cardenas votes aye. Mr. Ruiz. Mr. Ruiz votes aye. Mr. Peters. Mr. Peters votes aye. Ms. Dingle. Ms. Dingle votes aye. Chairman Walden.
Walden votes no.
Chairman Walden votes no.
Oh, wait, I forgot to ask if there were members that had not cast their votes. Mr. Johnson,
Mr. Johnson votes no.
are there any other members that did not cast their vote? All right.
Mr. Chairman, on that vote, there were 20 ayes and 29 noes.
20 ayes, 29 noes. The amendment is not adopted. All right. Chair recognizes the gentleman, Mr. Butterfield.
Thank you, Mr. Chairman. I know not to speak until I'm recognized. Thank you very much. I have an amendment at the desk, number 38.
Thank you.
Mr. Chairman, may I proceed?
Well, we have to let the clerk read the amendment.
Amendment to the draft oversight plan offered by Mr. Butterfield.
Unanimous consent, dispense with further reading of the amendment. Now the chair recognizes Mr. Butterfield.
Thank you, Mr. Chairman. Mr. Chairman, my amendment will correct the title of the Assistant Secretary for Mental Health and Substance Abuse that was created by Public Law 114-225. The amendment is technical in nature and would simply clarify the Assistant Secretary's title within the oversight plan to ensure that it reflects current law. It is important that this committee's oversight plan reflect our bipartisan commitment to mental health and substance use issues. Under the bipartisan reforms to our nation's mental health and substance use programs passed last year, many improvements were made to strengthen our country's ability to provide substance use services to those who need them. Included in the new law was $1 billion for opiate abuse response, funding for substance use disorder programs in targeted areas, evidence-based intervention grants, crisis response grants, and the creation of a substance use policy laboratory. It is important that this committee's oversight plan accurately reflect Congress's intent to elevate both mental health and substance use issues by clarifying the Assistant Secretary's title. I urge my colleagues to support this amendment. I yield back.
Gentleman yields back the balance of his time. Are there any members seeking recognition? Gentleman from Pennsylvania, Mr. Murphy.
I agree and move we adopt.
And yield back the balance
Yield
of your
back.
time. Are there other members seeking recognition? Seeing none, the question now comes before us on adoption of the Butterfield Amendment. All those in favor will say aye. Aye. Those opposed, nay. The ayes appear to have it. The ayes have it, and the amendment is adopted. Now we'll go to my friend from California. For what purpose does she seek recognition?
Mr. Chairman, I ask unanimous consent to call up my amendment with Representative Kennedy's amendment en bloc.
The clerk will report the en bloc amendment.
An en bloc amendment offered by Ms. Matsui.
Unanimous consent to dispense with further reading of the amendment. Chair recognizes the gentlelady from California.
Thank you, Mr. Chairman. My amendment would ensure that the committee continue and expand upon critical work to improve mental health services in this country. Millions of Americans across the country rely on Medicaid for mental health care. The Medicaid program is not only a safety net, but a foundation for mental health services. With Medicaid, low-income families have access to everything from depression screening to hospital and community services during a crisis, to substance use disorder prevention and treatment. The Affordable Care Act has made these services available to millions more Americans who otherwise may not have been able to access any affordable mental health care. That includes nearly 2 million Americans who have gained access to substance abuse treatment under the law. We must ensure that the gains we have made under the Affordable Care Act for people with mental illness or substance use disorder are not lost. A repeal of the Affordable Care Act would immediately and devastatingly do that. This committee has a responsibility to our nation's parents and families who suffer without access to care. I urge my colleagues to support this amendment. Thank you.
Gentlelady yields back the balance of her time. Are there other members seeking recognition? Chair recognizes the gentleman from Pennsylvania, the chairman of the Oversight and Investigation Subcommittee, Mr. Murphy.
Mr. Chairman, on this, I would see that this is unnecessary and somewhat redundant. In September of 2016, the Subcommittee on Health held a hearing entitled An Examination of Federal Mental Health Parity Laws and Regulations. This committee has been very supportive of mental health parity. And during that hearing, we reviewed the mental health requirements under the Patient Protection Affordable Care Act, the former administration's Interagency Mental Health and Substance Use Disorder Parity Task Force, Title VIII of the Families and Mental Health Crisis Act, as well as the Mental Health Parity Act of 1996 and the Paul Wellstone and Pete Dominici Mental Health Parity and Addiction Equity Act of 2008. And even more, as part of the 21st Century Cures, we passed our breakthrough mental health reforms. These are part, as people know, a multi-year bipartisan investigation. I am confident that the members of this committee and subcommittees are absolutely committed to working this, not just with the Affordable Care Act, but quite frankly, many of those aspects of parity and other health care delivery are separate from the Affordable Care Act, standalone laws, and we will work those things. Believe me, we didn't work so hard on this without having a commitment to do that. And with that, Mr. Chairman, I would...
Gentleman's time has expired. Any other? Yes, a gentleman from Massachusetts recognized.
Thank you, Mr. Chairman. Appreciate the comments from my colleague, Mr. Murphy. And as he indicated, we did pass the 21st Century Cures last Congress on broad bipartisan support. However, it was, despite the gains made there, it's a far cry from the comprehensive reform that our country needs with regards to its mental health system. I'm disappointed that the oversight plan today doesn't build on that momentum going forward. The document doesn't even mention the word parity, much less the words substance use disorder. 21st Century Cures was was supposed to be an effort to build upon that existing framework of federal laws and programs, including the Affordable Care Act, that promote prevention efforts and expand access to treatment to individuals with or at risk for mental illness and substance use disorders. As you know, the Affordable Care Act substantially expanded mental health benefits by requiring that insurance companies and all parties, both managed care and fee-for-service of the Medicaid program, as well as a CHIP program, cover mental health and substance use disorder services, including behavioral health treatment. Before the ACA was passed, many of the plans did not pass those, or did not require those necessary services, and I respectfully request that my colleagues vote yes on this amendment as we try to make sure that these reforms are put in place going forward. I yield back.
Gentleman yields back the balance of his time. Are there any other members wishing to speak on this amendment? If not, the question now arises on approval of the Matsui amendment, correct? And those in favor will, you want a recorded vote? With the request for recorded vote, those in favor will vote aye, those nay. The clerk will call the roll.
Mr. Barton. Mr. Barton votes no. Mr. Upton. Mr. Upton votes no. Mr. Shimkus. Mr. Shimkus votes no. Mr. Murphy. Mr. Murphy votes no. Mr. Burgess. Mr. Burgess votes no. Mrs. Blackburn. Mrs. Blackburn votes no. Mr. Scalise. Mr. Latta. Mr. Latta votes no. Mrs. McMorris-Rogers. Mrs. McMorris-Rogers votes no. Mr. Harper. Mr. Harper votes no. Mr. Lance. Mr. Lance votes no. Mr. Guthrie. Mr. Guthrie votes no. Mr. Olson. Mr. McKinley. Mr. McKinley votes no. Mr. Kinzinger. Mr. Kinzinger votes no. Mr. Griffith. Mr. Griffith votes no. Mr. Bilirakis. Mr. Bilirakis votes no. Mr. Johnson. Mr. Johnson votes no. Mr. Long. Mr. Long votes no. Mr. Bouchon. Mr. Bouchon votes no. Mr. Flores. Mr. Flores votes no. Mrs. Brooks. Mrs. Brooks votes no. Mr. Mullen. Mr. Mullen votes no. Mr. Hudson. Mr. Hudson votes no. Mr. Collins. Mr. Collins votes no. Mr. Kramer. Mr. Kramer votes no. Mr. Wahlberg. Mr. Wahlberg votes no. Mrs. Walters. No. Mrs. Walters votes no. Mr. Costello.
No.
Mr. Costello votes no. Mr. Carter. Mr. Carter votes no. Mr. Pallone.
Votes aye.
Mr. Pallone votes aye. Mr. Rush. Ms. Eshoo. Mr. Engel. Mr. Engel votes aye. Mr. Green. Mr. Green votes aye. Ms. DeGette. Ms. DeGette votes aye. Mr. Doyle. Ms. Schakowsky. Ms. Schakowsky votes aye. Mr. Butterfield. Mr. Butterfield votes aye. Ms. Matsui. Ms. Matsui votes aye. Ms. Castor. Mr. Sarbanes. Mr. Sarbanes votes aye. Mr. McNerney. Mr. McNerney votes aye. Mr. Welch. Mr. Welch votes aye. Mr. Lujan. Mr. Lujan votes aye. Mr. Tonko. Mr. Tonko votes aye. Ms. Clark. Mrs. Clark votes aye. Mr. Loebsack. Mr. Loebsack votes aye. Mr. Schrader. Mr. Schrader votes aye. Mr. Kennedy. Mr. Kennedy votes aye. Mr. Cardenas. Mr. Cardenas votes aye. Mr. Ruiz. Mr. Ruiz votes aye. Mr. Peters. Mr. Peters votes aye. Ms. Dingle. Ms. Dingle votes aye. Chairman Walden.
Walden votes no. Are there other members wishing to be recorded? Are there any other members wishing to be recorded? If not, the clerk will report the tally.
Mr. Chairman, on that vote, there were 20 ayes and 29 noes.
20 ayes, 29 noes. The amendment is not adopted. We have reached that point in our markup where we told everyone we'd get to 6:15. We've actually gone beyond that to accommodate as many members' amendments as possible. And I know there was a bipartisan amendment, but I'm told that literally we don't have paper on it, unfortunately. So we will not proceed with that one. And at this point, I think we are ready to move to adopt the committee authorization and oversight plan. All those in favor of the adoption of the oversight plan as amended will say aye. Those opposed, no.
No.
The ayes appear to have it. The ayes have it. The plan is adopted. I want to thank everyone for their participation today. We have a lot of work starting next week, and we'll see you here. Without objection, staff is authorized to make technical and conforming changes to the resolutions adopted today, including the organizational meeting portion and authorization oversight plan. So ordered. Without objection, the committee stands adjourned.